Deputy Speaker.
As we resume after tea, the member for Caroni Central, your initial 30 minutes had expired. You have your additional 15. You care to avail?
Thank you very much.
Proceed.
Thank you very much, Mr. Deputy Speaker. I just have about 4 or 5 points I'd like to make, and I won't go beyond that. One of the issues here is the appointment of, in the bill itself, in the amendments, is the appointment of adjudicators. And I think the Chief Whip in his presentation talked about some of his concerns about that. And I noticed that in the appointment process, you have the JSC on the one hand, and then, of course, you have the president, meaning the cabinet, on the other. And I wonder if the government would not consider, for good order, given all the problems that we have been having with the Judicial and Legal Services Commission and the issue of appointments which are susceptible to accusations or allegations of possible political interference on the other. I wonder, given the problems in the JLC and given those kinds of possibilities, whether the government would not consider having the appointments of these officers simply by the Public Service Commission. Because they would then become officers of the state. And it is true, we might have some problems with the Public Service Commission, and we might have some issues about a lot of issues, including how long they take to appoint and so on. But I think there's a certain protection about that as well. I mean, we must not forget, whatever the problems now, how the Public Service Commission evolved as a commission in the first place in the 1962 Constitution, and then later carried over into the Republican Constitution of 1976. So I just want to mention that. The other issue I want to mention is an issue my colleague, the member for Urupuch East, mentioned again, and I did also support his point of view in the when we debated the registration bill, which is that, you know, these bills are about 18 years old, and they may well take some further amendments. I mean, they need to be looked at seriously. Now, the government has a habit that when it does not require a 3/5 majority, they don't take your amendments seriously. But I think that this is important enough, given what we have said about land, the issue of ownership, titles, the disputes that can accrue, the difficulty of dealing with these matters, and the fact that the AG said, look, he wants to settle this matter through these bills. If we really want to settle it, let's look at the clauses carefully and see if perhaps we might not need some further amendments. And I would ask the government to consider that. The other thing is that the issue of penalties for officers. Now, when I raised this matter on the registration bill, Mr. Deputy Speaker, and you were presiding at the time, I said that there were penalties for members of the public who did wrong or who were found to do wrong, but there were no penalties for officers who violated the power that they had in their office in order to do wrong. And I have looked at this bill again, that is to say, on this adjudication side, and I want to tell you that it is just not there. All right? So it says, for instance, on page 8 of the amendment bill, it says here, where an adjudication officer records title, etc., and then goes down, and no, this is, I don't want to deal with that one yet. In this particular matter, this is in part 5, miscellaneous in the bill itself, the parent bill, the Land Adjudication Act of 2000. On on part 5, miscellaneous, all right, any person who having been served with a summons, etc., willfully neglects to or refuses. But these are members of the public, Mr. Deputy Speaker. And then it goes on to say, this is in 25, and in clause 26, no personal liability shall attach to the adjudication officer, demarcation officer, recording officer, or survey officer for any act or omission done or omitted to be done in good faith in the concurrence or discharging of their duties, and so on. And then it goes on to say the minister may make regulations, so to speak. So here you have punishable offenses by the general public, but you have complete absolution before the fact for the officers who are in charge of the process. And I just raised the issue of how they would be appointed. And I don't know if the JLC has the knowledge of land, etc., to appoint these people. I don't know if we are going to be sufficiently satisfied if Cabinet appoints these people. And I think that whether or not they are appointed, if they hold high office and they are accountable officers, I think that there should be penalty attached for violation of their office. And I feel that this is a severe flaw in the bill. You cannot have people with power without accountability and sanction. And that goes for everybody. You know, we have situations in this country in which there are officers who seem not accountable to anybody in the country. And these are high officers. So I feel that this is something that needs to be addressed. So I raised the two issues, the way the officers are appointed, and secondly, how do you have sanctions for violations? And I raised the issue of maybe looking a little more carefully, and the government at least acknowledging amendments that we might put forward and taking them if it makes the bills better and if it helps to establish a regime of better order and greater transparency and fairness in the society. And finally, I will close at this point. I want to say that when I was speaking on the last bill on registration, the Attorney General on many occasions got up and talked about the fact that I was anticipating. You know, when I was talking about the GIS issues, the thing. When I look at this bill and the amendments, I want to say that nothing is anticipated here. You know, I mean, the things are relevant here as it was then. And I don't believe that the AG or anybody else on the other side, including the leader of the House, should prevent a member from speaking on the bill as freely as possible, because at the end, we must not forget what the legislature is. The legislature is a place in which you bring the bill, the government brings the bill. The government brings a bill, and the opposition debates the bill with the government. In larger legislatures within the same system that we operate, all right, derived from the system in England, there are backbenchers on the government side that may hold a different point of view from the minister presenting the bill. And they would have the freedom to speak. And it is possible that those may influence amendments. And the point of the opposition debating and taking a different view and trying to argue and maybe broaden the debate and so on is to bring a wider point of view to the debate. Because the person outside, while we have to follow the standing orders here and keep within the rules, and I do not object to that at all. If you have rules, you live by them. The standing orders have to be, you have to abide by them. I have no problem. And you have an adjudication officer, you have the speaker. So, but the public at large is not interested only in narrow law. They are interested in how the law is going to affect me. In other words, what is going to happen to my land? What is going to happen to my property? What is going to happen to the issue I have before the court? What is going to happen to the person who's threatening to take away my land? What is going to happen to the person who take a piece of my land and sell it, although it's not his? The person outside there wants to know about these things. So I'd ask the government, in the spirit of good law, first of all, if they would consider amendments to be put forward by the opposition on this particular bill, and secondly, if they would, as we conduct our business, understand that we have not come here to break anything. We have come here in order to contribute and to build a nation. Thank you very much.
I recognize the Honorable Prime Minister.
Thank you very much, Mr. Deputy Speaker. I join this debate if only to add my support for what I consider to be far-reaching but apparently mundane legislation. Mr. Deputy Speaker, my colleague from Caroni Central just hit the nail on the head when he said that it would have been more beneficial if we had allowed members of the House to, as he said about his side, broadening the debate and being able to not be challenged about anticipation or repeating. And that is precisely, Mr. Deputy Speaker, why the leader of government business had asked that these pieces of legislation, all three of them, we should address them in the same debate so that it would have allowed my colleague from Caroni Central to roam a little more freely. So having not had that agreement, which was what had happened before, he can't come now and claim that if a member objected to him going outside of what is in front of us, that we are preventing him from speaking. I want to tell my colleagues on the other side, we have some authority in this country. One authority we do not have as government is to prevent you from speaking. That lies with the chair.
That's right.
Mr. Deputy Speaker, as my colleague from, we were joking before he started, Caroni Central indicated, he mentioned Tobago. You know, Mr. Deputy Speaker, I'm from Tobago. And you might not also know I also grew up on land in Tobago. I know a lot about land in Tobago. I'm a land owner in Tobago. I'm a land, how shall I put it? It is, I'm a registered farmer, yeah. Thanks. I'm a registered farmer. I'm a practicing farmer. But Mr. Deputy Speaker, for those of us who grew up in Tobago, I don't know any of us who would not be very cognizant of the land issues that we grew up with. Because there are very many people in Tobago who would have grown up on a parcel of land, a house on a parcel of land, and would have heard the grandparents say that somebody earlier on would have said that that parcel of land, by just pointing, belonged to this child or that child. And, you know, so land ownership over time became quite complicated because the occupancy and the records were not in sync. And it has led, as the Attorney General has pointed out, to some very, very unpleasant developments, even within families from time to time. I remember when I was working in Roxborough, there used to be a courthouse in Roxborough. And I don't know if it still exists, but there used to be court in Roxborough. And invariably, the matters in that courthouse were land and boundary. And many instances, it involved violence. And even in my own neighborhood in Mason Hall, I distinctly recall as a little boy being terrified when I saw some members of my family and some neighbors getting close to being physical over land disputes. And those of us in Tobago know that, and that largely is because the whole question of identification of parcels of lands, accepted identification. And that is why this bill that we came here today to pass into law is so important, to bring about not the end of the journey, but the beginning of the journey, to get to a place that I'm familiar with, because at an earlier time I had the portfolio of Minister of Lands in the period 1991 to 95. And one of the things that we aimed to do then was to bring this country to a place where all our lands could be identified by the unique identifier. Each parcel of land in this country, wherever, it doesn't matter who owns it, wherever it is, we should have a system where that parcel of land is identified as a unique location with its established and accepted boundaries. And this is where we're heading. And this land adjudication bill is putting in place the mechanism, the structure, to allow us to do that. And when we do that, and when we have that in place, a lot of the problems that we grew up with, that we live with, that we will continue to live with, and they will get worse over time, those problems can be addressed and will begin to recede from the culture of land mismanagement in the country. Mr. Deputy Speaker, early in the proceedings of that expectation, we established the Office of Commissioner of State Lands, the state being such a big landlord in the country. And that was a position that was meant to go in the same direction. And today, the clauses in this bill, if we examine what each clause is meant to do, you will see how purposeful the exercise has been. This matter has been lying around, I shouldn't say lying around, has been attended to over a very long period of time and over a number of administrations. And I think what has happened is that we strove to improve it, and we are also striving for perfection. But I want to say to the House today that while we may not have the perfect law in front of us, we have good enough law to be acceptable and to be accepted to start this process. And I'm sure that sometime in the not too distant future, experience will show that we may need to tweak it here and there. But I think we shouldn't delay the progress anymore, given the amount of work that has been done and how much effort we have put into trying to answer the questions that have been raised. I heard today one of my colleagues say that we want to put something in place so that there will be no corruption. Well, that condition doesn't exist. There's no law that you would put in place that you can say, well, this law is now in place, and as a result of it, or any situation for that matter, there will be no corruption, because corruption by itself is a deviation from what exists or what ought to exist. And whatever it is, once human beings are going to deviate from the expectation of the straight and narrow, then you're going to get corrupt practice. I mean, if I am to wax biblical, in heaven, there was perfection. There was a period of perfection. And that's where Lucifer came from. There was corruption in heaven. That's what we're told in the Bible. And one doesn't get more perfect than that. So I don't know that we can delay this thing to establish a law which one day we'll say, all right, you know what, we come to the point where everything is so correctly put in place that there's no opportunity for corruption, there's no opportunity for mismanagement or so on, and therefore we can now proceed. I think that is the perfection that will delay us into greater difficulties. Let me say this, because we're doing them one by one. This piece of legislation, the land adjudication, provides comfort, particularly for the same people that my colleagues on the other side were identifying as being nervous. Why should they be nervous? They should not be nervous about a system that is now going to identify their parcel of land, treat with their status, and improve their hold on the parcel of land that they have. But again, I could understand why it is raised as an item of concern, because we have developed in this country a culture of moving targets with respect to the accessing of lands by persons who are not owners of those lands. I've been around this parliament long enough to know that we've shifted those goalposts. We came to the parliament once and we said, and I'm here dealing with the squatting issues that were raised and the concern for squatters. We came to the parliament and we said that we accept and acknowledge that many areas in our country, persons have squatted on lands and have been there for some extended period of time, and such persons should be given the opportunity to own those lands and to use them, to continue to use them. And we passed a law to cover that. And we put a cutoff date, and then we said, from here on in, we would not encourage any more squatting so that we can manage the country without that. Lo and behold, a few years later, we have another explosion of squatting, and then we come and we adjust that again. And squatting continues to be an action in Trinidad and Tobago, particularly in Trinidad. And we still acknowledge by way of the parliament that up to a particular period of time, we will treat with persons who had squatted on lands. But what about the ones who squatted yesterday and the day before, and the ones who will squat tomorrow? How are we going to deal with that? Because if we are continuously having to treat with new squatters, we are never going to be able to properly manage the country's lands. And I'm surprised that my colleagues on the other side are raising this in a situation where we're saying we are putting in place land adjudication laws and a tribunal which would treat with complaints from persons who may believe that they have not been fairly dealt with by those officers whose job it is to determine who really should be on a parcel of land under this law. This tribunal is the key to the whole thing, because it will allow redress without going to the court. Somebody said a while ago that not everybody can go to court, not everybody has the means to go to court. Well, the bill itself deals with that. That is the whole idea behind the tribunal. So the bill deals with that. So it's not helpful to tell the public that, well, you know, if you have a problem and you have a complaint, you have to find money to go to court and find a lawyer and go through the slow court system and so on. No. The bill deals with that by way of the tribunal. And if I come back to Tobago, one of the main complaints we have had in Tobago is that because we have not been able to deal with the titling of Tobago because of these historical antecedents, people have not been able to enjoy the full value and benefit of their ownership and access to these lands. And in today's economy, your equity, your ownership, your claim on a piece of land is very valuable. And I'm happy that this process of the IDB program, the identification of land and pressing forward with this is happening in Tobago, because that relief had been requested, begged for many, many years. And I want the people of Tobago to understand that this bill, this law, and this exercise is going to fundamentally change the uncertainties of land ownership, which has been affecting Tobago for generations.
That's right.
And as we move towards the parcelization and the identification and the unique identifier, we come to a point where everyone, by this process, would know where the land is, where the boundaries are, and whose land it is. And then we can transfer land, we can sell land, we can buy land, we can own land without the aggravations and the uncertainties that exist with Trinidad and Tobago. That's where we're heading. And I want to thank and congratulate the Minister of Planning and Development for the work that's going on in that ministry. With respect to the operationalization of this, and I want to thank the Attorney General and his team and the teams that went before, because this exercise has been so laborious over time that it has crossed administrations, and some people find these kinds of laborious assignments not exciting, and they tend to get to the back burner. But coming here today at 10 o'clock this morning to try and get through this is the government's intention and expectation that we will conclude the third piece before we go into the Easter vacation, because we had set ourselves as part of our legislative program, and by commitment, again, to the people of Tobago in particular, that we will get this done by the first half of 2018. So I think we are on track to do that. And if we get that done, Mr. Speaker, Mr. Deputy Speaker, it will be a watershed day in Trinidad and Tobago, because we would have laid a foundation for land management in this country that would serve all of us well.
That's right.
I heard my colleague from Kumuto Manzanilla talking about protecting lands and, unfortunately, not being properly informed about the route that's being followed in the Kumuto Manzanilla project. I was a little taken aback by that, Mrs. Deputy Speaker, because, you know, my other colleague, I think the one from Orapooch East, said that if the government had held her hand and explained to her what we are doing and not be so secretive and in the absence of information that would cause people to think the worst. Well, Mr. Deputy Speaker, that might be very true of all other situations. The one situation where that has no currency and no seriousness to it is the Kumuto Manzanilla Road. Because, see, Mr. Deputy Speaker, I was there when a presentation by the relevant authority was being made to the public, the invited persons and the public, one of whom is my colleague from Kumuto Manzanilla. A presentation to show where the reserve is, where the road is passing, where it is connecting to the existing highway, where it is leading to, and so on. A presentation being made by the state agency. My colleague from Kumuto Manzanilla had an invitation and a reserved seat in the front.
That's right.
And what did she do, Mr. Deputy Speaker?
Let it go.
While the presentation was commencing, she walked into the function,
Mr. Speaker, that is
handed a letter.
Stand in order.
48. To give Prime Minister to give way. I'm asking the Prime Minister to give way because the presentation was
You have given the
I have not given way, Mr. Deputy Speaker. Take your seat. Go sit down.
stand in order, member. Member, stand in order.
Mr. Speaker, Deputy Speaker, I'm talking to you. And I'm referring to what was said by my colleague from Orapooch East about secrecy in the government's operations. And he ascribed that alleged secrecy and lack of information and public content to explain why his colleague from Kumuto Manzanilla could have come here today and join misinformation that the government is building a highway through the Aripo Reserve. I'm saying to you, Mr. Deputy Speaker, that the one person who cannot truthfully say that is that member for Kumuto Manzanilla.
That's why.
Because the presentation, the pinnacle of the presentation, on site, my friend from Orapooch East said the government should have taken people to the site. Well, yes, we were on the site, and I was wearing my boots on the site because it was a muddy day. And Mr. Deputy Speaker, that day, a presentation in front of the media was made. My colleague from Kumuto Manzanilla came, a reserved seat in the front for her, to be informed as to what the project is, and she chose, instead of paying attention to what was going on in her constituency and the government's public information, to play postman from heaven and bring for me a letter from God, and claiming that God gave her a message to give me, right?
Silence, members.
I took the correspondence and I could not believe what I was receiving. And worse, having delivered her correspondence from God, she left promptly without staying to receive the presentation. I stayed as Prime Minister, and I was educated by the presentation, and that is why I know that any person who is telling this country that the highway from Kumuto to Manzanilla is going through the territorial reserve is speaking an untruth and a deliberate act of misinformation. And when the government makes a presentation in front of the media with charts and documents and statements by the requisite officers, I do not think that my colleague from Orapuch East could say seriously that the government was acting in secret. What I think he has to do is check his colleagues and see which one of them belong in St. Anne's.
Excuse. Honorable PM, could you rephrase or retract, please?
I think to rephrase, Mr. Speaker, I live in St. Anne's. I live in St. Anne's. Mr. Speaker, and you know, Mr. Speaker, she represents the UNC, and she comes with that misinformation, trying. Mr. Deputy Speaker, I apologize to my friend from Kumuto Manzanilla. She's not a she. The member for Kumuto Manzanilla. Not a she. Mr. Deputy Speaker, that was done against the background. Mr. Speaker, I want to speak to you. They could make the noise. I'm talking to you. That attempt to talk about environmental concern in this debate today comes from a spokesman, Mr. Deputy Speaker, I am being distracted by my colleague from Kumuto Manzanilla.
Members would have had the opportunity to speak in the debate already. Other members will have the opportunity. At this time, I'm recognizing the Honorable Prime Minister. Please, let's listen in silence. Member for Kumuto Manzanilla, I am hearing what you are saying. Honorable Prime Minister.
Mr. Deputy Speaker, the member for Kumuto Manzanilla is accusing me of talking a set of lies. I want to know if the member for Kumuto Manzanilla didn't come to Kumuto with a letter from God and deliver it to me and left. I'm simply reporting what happened at the presentation in Kumuto Manzanilla. And I can't for the life of me understand why the member is now disowning her communication. But I'm simply saying, Mr. Deputy Speaker, that attempt to talk about environmental concern seems to be a recent development with this opposition. Because, Mr. Deputy Speaker...
Excuse me, Standing Order 48-2, Deputy Speaker, on the matter of what he's talking about.
On what, sir?
On the lands on the highway. The matter is in the court.
Overruled.
Mr. Deputy Speaker, apparently my colleague from Pointe-a-Pierre, apparently was not paying attention to the debate. I'm simply responding to issues raised on his bench. Kumuto Manzanilla was talking about environmental preservation and government action. And I'm saying, I'm glad to hear that my colleagues on the other side have come to that place where they can now take that position. Because they did not take that position about land to be protected for public purpose and for environmental sensitivity when they issued certificates of comfort on the Diego Martin play field. And as Minister of Housing, we had to go and buy back the land from the people that they had given certificate of comfort to, so as to be able to build the Diego Martin Sports Complex.
Exactly.
And even as the sports complex was left unbuilt, they went back for a second time and issued certificate of comfort on the same land that the government had acquired from before. So I don't know why they come in here. This is the history. This is the fact. I'm not making this up. What? So how come in one breath you are so concerned about public lands and environmental situations? There was a campaign, there was an election campaign here in 2010. And from that, as we talk now about protecting lands and managing lands properly, it was the leader of those on the other side who made a call for squatters to go and squat and say to them, we will find you wherever you are. That is not management of the country's lands. What this bill will do is to ensure that those persons who are properly on lands, as squatters who are being regularized, will get the protection and will move to the point of proper ownership of those lands. But we also will be in a position to not have continuous squatting for all kinds of purposes taking place in the country. Because the laws indicate what lands will not or should not be considered for those kinds of purposes. Lands for a public purpose, like in Diego Martin for the public playing field, lands which are environmentally sensitive, like Aripo Savannah, and so on. And if we do that, there's no need for anybody to come and misrepresent and to play environmentalists when the law is there for all of us to observe. And there are tens of thousands of persons who, for the first time through this process, this adjudication process, will move towards proper, clear, and identifiable ownership of land on which they've been occupying for quite some time. So it's a benefit. The clause in here which says that adverse possession comes after how many years? 16 years, as against 30 years? Who will that benefit? It will benefit persons who, after 16 years, rather than wait until 30 years to be regularized and to get the full benefit, to bring the laws in sync, that you now use 16 years. It's a fundamental change.
Private land.
Private lands, 16 years. It, what? State land?
For the state is 30 years.
Yeah, well then, and there's a good reason for that.
Exactly.
There's a good reason for that. God knows that enough state lands have fallen into hands.
Absolutely.
So we can't put anything in place that will increase that. But where there are issues, 16 years in the private sector, 30 years on state land. And most of our communities have already been dealt with because we have identified, every member of parliament was asked before to identify and report to the parliament on the squatter communities in their constituencies. And those are in the regulation, in the relevant law that governs the squatting act. So, Mr. Deputy Speaker, I think we should move ahead with this. I think we should go and pass this into law. Allow the operators to operate. My colleague from Caroni Central made a proposal that we should accept an amendment to use the Public Service Commission rather than the Judicial and Legal Service Commission to appoint the adjudicators. My legal advice is that it had been tested in the relevant courts of law, that the appropriate agency to make these judicial appointments is the Judicial and Legal Service Commission. That is tested law. And if we try to just arbitrarily change it for administrative convenience, we can come up against established laws. I think the AG will, might be able to assist a bit more with that when he concludes. But there's one other point I want to address, Mr. Deputy Speaker. I heard with a certain amount of interest the speaker from Oropouche East talking about the government valuator. I got the impression, knowing what I know, the difficulty that he is in with respect to the court documentation that he was attempting to try his case here today. I simply want to say,
Standing order 48-4.
What exactly are you referring to, member?
I'm referring to his saying that my colleague had motives for speaking today that were personal and in his interest.
Overruled.
thank you, Mr. Deputy Speaker. I was very careful to say that I got the impression. It appears as though my colleague from Naparima would deny me an impression. But I was simply reporting, Mr. Deputy Speaker, about my impression when the member for Oropouche East said that the government valuator is the person who has the authority and who the government relies on to value land. That statement was made in the context of what was said about Eden Gardens and what happened there. And my colleague from Oropouche East went on to say that exoneration was had from the Integrity Commission. I'm not making this up. While I was working upstairs, I was following the debate on the television. So I know what was said. And I got the impression that this had to do with the Eden Gardens legal matter in which he is personally involved. So, but I want to say one thing, Mr. Deputy Speaker. While it is possible and it is correct to say that the government valuator and the valuation division is the agency which is used for the government to get values.
Mr. Prime Minister, your initial 30 minutes has expired. You have an additional 15. You care to avail yourself? Yes. Proceed.
Yeah, while it is correct to say that it is the valuation division that is to advise the government on valuations, and that I don't think it's correct to say that commercial public license valuers have no role, because many instances the government departments rely on 1 or 2 or 3 valuations to come to a position. But if that is the defense, that my colleague is going to the court with, all I can say today is I wish you well.
I am not in any court on Eden Gardens. What defense?
My colleague from Oropouche East, my colleague from
Mr. Prime Minister, let me just rule and then you will proceed. Overruled.
My colleague from Oropouche East was at length to talk about exoneration by the Integrity Commission. Correct. And I'm saying, Mr. Deputy Speaker, if my colleague from Oropouche East takes comfort in the Integrity Commission's exoneration, I wish him well. Because I do not know, Mr. Can I?
As was stated previously, everyone had their opportunity, and I'm now recognizing the Prime Minister. So please listen in silence and ensure that the decorum of the House is maintained. Member for Naparima, your back is towards me first of all, and you're still... Members, silence. Okay? So again, Honorable Prime Minister.
Mr. Deputy Speaker, I could understand why my colleague from Oropouche East is so jumpy, you know. I am simply responding to the matters that he raised. He is the one who came here and gave us a long treatise about exoneration by the Integrity Commission. And all I'm saying to him is, as a colleague in this House, if he is relying on the exoneration of the Integrity Commission with respect to Eden Gardens, as your colleague from Degomartin West, I only wish you well. Wishing you well. Because, Mr. Deputy Speaker, I'm sure that my friend from Orapuch East would know I am sure that the distinguished gentleman from Orapuch East would know that if he ever turns up outside of the Integrity Commission, having to answer for why the HGC paid $120 million more for land.
Order 48-4 is correct.
That's a calypso.
Members, this is the third time or the fourth time I'm on my legs with regards to the statement being uttered by the Honorable Prime Minister. And as been stated before, those are matters that were raised, and I am saying that the Prime Minister is only answering accordingly. Overruled, proceed.
Mr. Deputy Speaker, all I know is that my colleague from Orapuch East came here today, and in response to my colleague from Aruka Maloney, he pleaded his case and he put off his defense. And I'm simply saying to him, if that is the defense that you're going to hold on to, right, I wish you well. And I don't know why I am being disturbed so frequently as I wish my colleague well. My colleagues on the other side are even disowning the very things that they've said here an hour ago. One brought me a mail from heaven disowning it. The other one get up and talk about Integrity Commission exoneration. He's disowning it. I don't know why that is so. Huh? I mean, I'm not going to put up a banner in the highway anyway and say, go straight to jail, don't pass go. I would not do that because I really don't want it to be said that I served in the parliament with a member from Orapuch East who did not have the kind of defense that he should have had and relied on Integrity Commission exoneration. I simply wish you well. Mr. Deputy Speaker, to get back to the point of the adjudication bill that's in front of us, it is not very often that we are able to complete exercises like this, which have taken such a long time. And there might have been very good reason why this piece of law took so long to come to the House. And I heard it said that more than once that we should be careful about who is appointed as adjudicators and that there should be no political interference and so on and so on. But these observations are noteworthy, but at the end of the day, we have to have public servants conducting public business. We have to have politicians who are conducting the political management of the country. And what we have to do is to ensure that there's accountability at every stage in the process. And once we have accountability at every stage in the process, we can hardly do better than that in preparing these operations and in carrying out the service of the people who will benefit. Tens of thousands of people initially will suddenly benefit. And then after that, continuously, the management of the state's land resources, whether they're private lands or state lands, will be better handled for the benefit of all those who own the state lands, which is the whole population, or those who own private lands on an individual basis. Mr. Speaker, I want to end by simply saying that I am pleased to be associated with this far-reaching piece of legislation, and I have every confidence that if we go about it positively, believing what we have all said, and supporting it in the end, having supported it at birth, that we will change the country for the better with respect to management of land in Trinidad and Tobago. I thank you, Mr. Speaker.
Standing order 44-8.
44-8, you said? Decline.
Not quarreling, he's addressing an issue under the relevant standing.
What you want to clarify, Member for Buchis?
Mr. Deputy Speaker, I'm explaining to you what I want to clarify. The member for Aruka North raised the matter of Eden Gardens. I made the point that the Eden Garden matter was handled by the Integrity Commission before, and the HDC was cleared of that. The Prime Minister suggests that that matter is before, at this time, the Integrity Commission, and said that I was making a defense. At the last time I examined the reports of the Integrity Commission, there was no ongoing investigation on Eden Gardens. So I cannot be making a defense and has misrepresented what I have said earlier in the proceedings. There is no matter before the Integrity Commission today, and that was a deliberate attempt to mislead with malice. And if he likes my name, he should call it outside.
Okay, your 2 minutes has expired. Minister of Finance.
Mr. Deputy Speaker, I really do not understand what the member for Oropuch was about. I do not recall the Honorable Prime Minister making any allegation with respect to the Integrity Commission. I don't recall that. Perhaps the Honorable Member was in another place when the Honorable Prime Minister was speaking. I see we have more than one presiding officer here. So, Mr. Deputy Speaker, I've listened to what the opposition has to say, and it's a familiar refrain coming from the other side. What beats me is that it's well established that if you have to litigate matters, litigate disputes, and I want to read from something here. A litigated civil dispute can take months or even years to work its way through the court system, draining both disputing parties of resources while each waits for settlement in his or her favor. Now, any persons who have been into the court system will realize how debilitating it can be, especially if it's a contentious or acrimonious matter, civil matter. Any person who has been into the court system will understand that. Any person who has been into the court system would understand the concept of draining of resources. This is not just monetary resources, time, health. Anyone who has been engaged in a contentious, long-standing legal matter would understand this. But yet every time, Mr. Deputy Speaker, as we did with the property tax matter, and we have done with other pieces of legislation, every time this government comes into this parliament to introduce a form of alternative dispute resolution, every time to relieve aggrieved persons of having to go and engage expensive lawyers and having to confront the legal system, which in many instances they are completely unfamiliar with. There are persons, I am talking about the Land Adjudication Act, because what this act is all about, Mr. Speaker, is to operationalize a system that was enacted into law but never put into operation 18 years ago, Mr. Speaker. I looked at the original Land Adjudication Act. Mr. Deputy Speaker, this muttering, it's difficult. Could you ask the honourable member to stop?
Okay, again, members, while the member is speaking, the rule is listening silent, and I would like to hear the discourse. Minister of Finance.
Thank you, Mr. Deputy Speaker. And as you say that, the member for Oropochi starts to mutter again, little child. Mr. Deputy Speaker, anybody who has entered the system will recognize that many litigants are at a severe disadvantage. Many litigants are not even aware that if you get a judgment against you and you don't get a stay of execution and you are facing an aggressive claimant, you will soon be facing the outcome of a writ of execution, of enforcement, a writ for enforcement of the judgment, and finally, a levy. A lot of people go into the court system, they don't understand that, you know. So they get a judgment against them, and they're not aware that they have to appeal the judgment and apply for stay of execution. And if they don't apply for stay of execution, if the claimant or the successful party is a combative person, you will end up with a writ of execution and a levy against you, and you'll be in distress. A lot of people don't understand that. A lot of people don't understand how long the system takes to work matters through. I'm familiar with matters that have taken 25 to 30 years to work their way through the system. Can you imagine, Mr. Deputy Speaker, being involved in a dispute over land for 30 years? Within that period, members of the family would have passed away. The disputed lands would have been inherited in inverted commas by the heirs of the person who claims title. What this amendment bill seeks to do is to introduce a number of due process improvements to the law.
That's right.
That's all this thing seeks to do. You have a law there already for 18 years where you had a system of land adjudication. It's an intermediate process before you get to litigation. And there's another act already in the system, Mr. Deputy Speaker, the Land Tribunal Act. And there are so many checks and balances in this process. You go through the system of the Land Adjudication Act, and if you are not satisfied with the outcome of the process, and they are the usual safeguards in the Act, the Land Adjudication Act. If a process is completed and someone who is claiming title to a piece of land is dissatisfied, then they do the usual thing. They appeal to the person who made the decision to review his decision. And then if the person reviews their decision, and we have this in the procurement legislation as well, where if a person is aggrieved at the decision of the regulator, they appeal to the regulator to revisit and review his or her decision. Same thing in the Land Adjudication Act. So there's an adjudication on a piece of land, and the land adjudicator has determined that a particular parcel of land belongs to a particular individual, and that these are the boundaries of this land. So he declares that the title belongs to a particular person, and he declares these are the boundaries of the land. And the compensation thing comes in, where if in fact you are the real owner or the truthful owner of a piece of land, and you have been deprived of the use of that land over a period of time because of a dispute over ownership, then the question of compensation comes in, and an order is made for compensation to the person who suffered a disadvantage. But the usual process, an adjudication is made after a survey is done and evidence is gathered, a decision is made, and adjudication is made. The person then appeals to the land adjudicator for review. If he's dissatisfied with that, he then goes to the land tribunal. And if the land tribunal renders a decision which he's dissatisfied with, he's entitled to appeal to the Court of Appeal. That's the process. And then, of course, you go up to the Privy Council. So there are numerous checks and balances in this system. But what the Land Adjudication Act is seeking to do is to clean out a number of frivolous or obvious matters before it gets to the Land Tribunal and goes to the Court of Appeal. That is the whole purpose and intent of alternative dispute resolution. In England, you have an adjudication system with construction disputes. And you have a system of adjudicators in England dealing with contractual disputes over construction works that has been working well now for over 25 years, Mr. Deputy Speaker. And what that is intended to do, many people do not wish to go to court. In fact, that is how arbitration began. It began in the mercantile trade, where owners of vessels carrying goods to far distances, there was so much at stake. There was so much at stake that if you didn't settle the dispute quickly, you could lose all of the items on the ship, the goods could perish and so on. So in the mercantile trade, they came up with arbitration as a quick and easy way. Yes, a quick and easy way of settling disputes because there was so much at stake. And in the construction industry in the United Kingdom, they have come up with an adjudication system for construction disputes. And 80 to 90% of the disputes are settled at that level. 10 to 20% go on to court. So you weed out 80% of the matters in the system, and you reach a decision with which the parties are satisfied. This is what this is all about. You don't want to continue this system where somebody has to be in court for 25 to 30 years to determine who is the owner of a piece of land. And I can give you a personal experience. I had sought to purchase a piece of land, and Tobago is an interesting place. It's an interesting place because in many parts of Tobago, what we have in Trinidad, I don't know what the correct terminology is in Tobago, I will stand to be corrected, but in Trinidad you have what is called minus property, where land is passed on to somebody without a will, and then it is passed on to another person without a will, and so it goes, may come down 3 and 4 generations. That's what we have in Trinidad. I don't know if in Tobago it's called minus property. But I sought to acquire a piece of land in Tobago, and having done this before, I asked the conveyancing lawyer to search the title. I had been assured that the title was good. The lawyer came back to me and said, Mr. Imbert, you sure you want to buy this piece of land? I said, what's the problem? He said, look, I found that in 1960, somebody just occupied this piece of land and then claimed possessory title. When you go to the root of the title, they were not the original owner. The root of the title was somebody else. But in around 1960, 1965, somebody just decided to occupy the land, stayed on the land for 25 years, and then claimed possessory title of the land. And it passed through the system and passed through... Mr. Deputy Speaker, I'm being disturbed.
Again, members, silence.
Mr. Deputy Speaker. So the title passed through the system for more than 50 years. Several lawyers after that certified the title as good. Distinguished lawyers in the community certified the title as good. But when you looked at it, you saw that there was a possessory title somewhere back in the 1960s. I chose not to buy the land because I would have had to go through the real property ordinance and do all the procedures and all the processes in order to acquire the land and ensure that I had proper title to the land. And the real property ordinance system can take up to 2 years, not so, Attorney General? And you have to advertise it, and you have to allow persons who claim to be the rightful owners of the property to come and make representation that they are the owners and not the person that you seek to buy it from. So I didn't bother. I just left it. But I am told that in Tobago, there are many areas of Tobago, because of the fact that property has been passed on from generation to generation without the proper paperwork, that there are many situations such as the one I just described. And what will this act do? This act will create a system where an officer, will now be authorized, the adjudication officer will now be authorized based on the work done by the demarcation officer. And you know, they like to use big words, but all a demarcation officer is a land surveyor. That's what it is. It's a land surveyor. That is what the Act says. It's a land surveyor. Yes, a land surveyor. So that a land surveyor, Mr. Deputy Speaker, a licensed land surveyor under the laws of Trinidad and Tobago will be the demarcation officer or survey officer. That's what the law says. Go and check it. Go and check the Parent Act and you'll see that. So a land surveyor will come in and have the authority of a demarcation officer, will investigate the property, will look at evidence, will receive submissions from persons, and the demarcation officer will determine that these are the boundaries of the land and this is the rightful ownership, and make a recommendation to the adjudication officer, who will then make the final determination. So what we've had here is a system on our books for 18 years, which for one reason or another, I don't know why, has never been put into operation. If this had been in operation since the year 2000 or the year 2001, I am certain that many of those matters, and it is not just in Tobago, Mr. Deputy Speaker, but it's also in Trinidad, all over Trinidad, my own constituency, in the beautiful area of Paramin. It is more common than it is not for property to be passed on to sons and grandchildren and so on without a deed. So you would have a large parcel of land, maybe 20 acres, and over time the family grows and it grows and it grows, and now you might have 30 or 40 members of this family, and what the original owner of the land would have done is say, right, that's your piece, and that's your piece, and that's your piece, and that's your piece. You end up now with 10 families having constructed dwelling houses on this large parcel of land, and the boundaries are demarcated by folklore. By folklore, and as the Prime Minister tells me, by fig trees and plum trees, and that, yes, and one, as the Honourable Member for Tabakit says, one man has the will. And then as people pass away, yes, if there's a will, and as people pass away and new people come onto the scene, you then end up with disputes. And I can tell you in Paramin, there are many parcels of land where title cannot be procured because there is no title that can be found. What this will do for my constituents in Paramin is give them, for the first time, the ability to go before a land adjudication officer and get a determination as to the boundaries and the ownership of the land that they have occupied for generations. And I salute the Attorney General for this package of bills he has brought to this House. I'm not anticipating. Last week we spoke about registration of title. Today we're dealing with land adjudication officers. Soon we will deal with the Land Tribunal Act, which is the appellate body arising from the decision of the land adjudication officers. And then we will deal with the State Lands Act, which deals with the whole problem that we have in Trinidad and Tobago of the ownership of state land. Exactly. I congratulate the Attorney General. This is something that has been festering in Trinidad and Tobago for more than 15 years. It should have been done long ago. And it has taken the commitment and the hard work of this Attorney General to bring this package here today so that we can finally get these laws onto our law books and have a proper determination of land. And it is especially for poor people, Mr. Deputy Speaker, the people who are most affected by the lack of proper title, by the lack of defined boundaries, by the lack of knowledge of proper ownership. My same constituents cannot go to the bank and get a loan and use their land as collateral because they don't have proper title to the land. Exactly. And this is going to assist them, and this is going to lift them in terms of their own personal wealth, in terms of their land ownership, and lift every constituent of every person in this Parliament, Mr. Speaker. So I don't know why honourable members opposite fussing about this. Alternative dispute resolution has been coming in this country for years. Exactly. If you look at the civil proceedings rules, you will see that at the front of those rules, the objective of the rules is to avoid litigation. Imagine that, the overriding objective of rules for litigation is to avoid litigation. And then you have had the development of mediation. Yes, you have had the family court, which is a very profound development into a less aggressive environment, a less litigious environment. And then you've had the development of mediation, Mr. Speaker. We've had a situation in this country over the last 10 years. I know personally of persons who have done courses put on by the judicial system and become certified mediators. And in many cases now, a judge or a magistrate will refer a dispute to one of these certified mediators so the parties can settle the matter among themselves and then come back to court with a consent order. Okay. That is the modern way, Mr. Deputy Speaker. This legislation is the way of the present and the way of the future. Well said. And no one should be fussing about this. And I give a commitment on behalf of the government. We will give the land adjudication system the necessary resources, the necessary funding that it needs, because it has been a long time in coming. I congratulate the AG again. I thank you, Mr. Deputy Speaker.
I recognize the Attorney General.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I wish to pay fulsome gratitude and thanks to my many colleagues who have spoken today. It's true at times it's sometimes hard to discern the points of distinction that the members of the opposition ask us to consider. However, there was merit in some of the positions put forward, which I propose to address. I wish to thank the Honourable Prime Minister and the Honourable Member for Diego Martin North East, the Minister of Finance, for really putting careful explanation of the benefit of this bill, its legitimate aim, into the context of two very important zones. One, the people of Tobago, all 300 square kilometers of it, close to 60,000 plus people living there. And two, importantly, as the Honourable Member for Diego Martin North East, who so eloquently and plainly set it out, spoke for and on behalf of the disenfranchised of this country. Because the Honourable Member for Diego Martin North East was absolutely correct. It is the people that have the least in our financial system, the least in our country, the least in our economy, who live on lands. And Clause 11, which amends Section 16 of the Parent Act, treats with the adjudication process. And let's put this in its most simple form. This bill allows for people who are living on lands in Trinidad and Tobago, and that is all lands, to pass through a state-funded, state-operationalized system where their title will be guaranteed absolutely. What does that mean? That means, Mr. Deputy Speaker, that everyone who lives on land to which they are entitled, whether it is private land, which is your own as inherited, whether it is private land that you have exercised adverse possession or squatted on for more than 16 years to the exclusion of a legal owner, or whether it be public land, state land, which you have exercised by way of continuous, uninterrupted occupation for more than 30 years, you will have the opportunity in the process of vesting applications to approach the Land Tribunal, to approach the adjudication methodology in this bill and go and ask for consideration in a cost-effective way. Why? The state pays for the demarcation or land surveying. The state pays for the tribunal. The state pays for the land adjudication process. The state pays for the adjudication officers, as this bill proposes. The state houses a repository of information. The state makes it available. And therefore, people move from the system of having to pay hundreds of thousands of dollars in certain circumstances, if not thousands of dollars and umpteen years. They get to avoid all of that and engage in the state process. There can be no greater legitimate aim in establishing the bona fides and proportionality of this bill as that, Mr. Deputy Speaker, and I start with that. Essentially, Mr. Deputy Speaker, there are a few points on the table. If I put it in very simple terms, number one, there was the repeating theme of members opposite about the construction of the adjudication methodology. Who comprises it? Who appoints these members? What are their terms and conditions? That's the first point. The second point raised by members opposite involved the operationalization and funding issues. How do we get this thing to work? What about the timing? Do we wait any much longer? The third issue which was raised involved essentially members asking about the adverse possession or squatting settling issues. The next issue which was on deck was please explain the 16 years versus 30 years dichotomy. And then there were some general issues as to how one manages fraud, how one manages other issues that are articulating around this bill. So let's deal with the most serious of the issues, which is whether the provisions of Section 4 of the Act, as we propose, are amended by Clause 4 of this bill, whether Section 4 of the Act, as amended and proposed to be amended, is in fact constitutional. The argument on constitutionality of the individuals that comprise the adjudication structure is one to be considered in a couple of ways legally. Number one, what does the Constitution say in relation to the appointment of these persons? What are the constitutional parameters that the courts have considered to understand whether there is an independence of entity such as to be insulated from the executive? We know, of course, the dicta that came out and stood in the R.V. Hines dicta in the Privy Council. We know that the prescription of Lord Diplock was that a country would do well to avoid the executive controlling events, put in its most simple terms. But the question of separation of powers also joins the constitutionality and legality argument. Will this tribunal, will this adjudication process and membership run afoul of any of the rules of separation of power insofar as there are to be persons appointed as follows? 1, a chief adjudication officer. 2, deputy adjudication officers. 3, demarcation officers. 4, surveying officers. When we look to those positions, it is important, if we're looking at the constitutionality argument, to answer the issue as follows. In the first instance, the chief adjudication officer and the deputy adjudication officers are set out by way of the amendments in Clause 4 to include the fact that they must be appointed by the Judicial and Legal Services Commission. Secondly, the demarcation officer and the survey officer, they are to be appointed by the President. Yes, it is true to say that if you construe Section 74 of the Constitution and Section 80 of the Constitution, President is read to mean the Cabinet. Yes, that's true. So we have two categories of appointments. The adjudication officers under the hand of the Judicial and Legal Services Commission, and secondly, the demarcation and survey officers by the Cabinet of Trinidad and Tobago, essentially. Is there anything wrong with that structure? On the one hand, I wish to point out immediately that the adjudication officer, the deputy adjudication officer, they are insulated, first of all, by the fact that the Judicial and Legal Services Commission is an independent entity enshrined in our Constitution to so act, which stands clothed by the protection of the Constitution in their operationality. An executive cannot interfere with the Judicial and Legal Services Commission. Their salary is protected, their terms and conditions are protected, their decisions are protected. Secondly, these two officers are also clothed by the operationality of Section 141 of the Constitution. Section 141 of the Constitution is the provision which brings to life the SRC, the Salaries Review Commission, so that the terms and conditions of the adjudication officer and deputy adjudication officer are constitutionally protected. Thirdly, we looked at the demarcation officer and the survey officer, and Mr. Deputy Speaker, we note in particular Section 9 of the Parent Act, subsection 9 of Clause 4, Section 4, Section 4(9) of the Parent Act notes that the demarcation officer and survey officer shall be Trinidad and Tobago land surveyors within the meaning assigned under the Land Surveyors Act. Now, these two classes standing side by side, is there precedent or anomaly in the law in recommending this structure? Honorable members opposite have asked for a move away from this. They sought to raise the usual specter that the opposition brings, which is executive interference, but I wish to put onto the record. There are many structures and laws in Trinidad and Tobago which use this process. The Mental Health Act, Chapter 2802, where there's a psychiatric hospital tribunal, that is appointed essentially by executive functionality. 2, the Emergency Ambulance Services and Emergency Medical Personnel Act, Chapter 2902, again, that appellate committee is appointed essentially by the cabinet. 3, the Civil Aviation Act, Chapter 4903, that appellate body is again appointed in similar structure. 4, the Electricity Inspection Act, Chapter 5472, again is a structure which is appointed similar to the one which we recommend. 5, the Architecture Profession Act, Chapter 9002, again with similar structure. But we don't stop there, Mr. Deputy Speaker. The fact is, the member for Oropouche East raised it. He said that, and I'm paraphrasing, that he made reference to the industrial court. And that was a very good reference to make, to hold on to. Why? Because the industrial court is comprised of a structure where you have the president of the court being appointed by the Judicial and Legal Services Commission. You effectively have that insularity in order. The terms and conditions shall be that either you are qualified to be a judge of the Supreme Court, appointed in the capacity from a judge of the Supreme Court moving there, or by the JLSC. And then secondly, you have the members of the cabinet appointing the other judges of the industrial court. So I was quite surprised that the member for Oropouche East would raise that as an example. I had hoped that he was going to raise it as an example to support the structures in the bill, but he turned away from that and somehow suggested that we should take a different point of view. Let me put on the record. The Privy Council of Trinidad, which is Trinidad and Tobago's highest court of appeal, in 2 particular cases, dealt with the sanctity and correctness of purpose in using structures such as this. The 2 decisions are, first of all, in the case of Paul Lai versus the Attorney General of Trinidad and Tobago. That Court of Appeal judgment, which I have in my hand, is Civil Appeal number P129 of 2012, and it is a decision rendered on the 9th of December 2014 by then Madam Justice of Appeal Paula May Weeks. And then the second case that is of reference is a Privy Council judgment. It's the case of Sam Maraj versus the Prime Minister of Trinidad and Tobago, which is a Privy Council decision given on the 19th of December 2016. Both of these judgments demonstrate that it is perfectly in order for there to be a blended approach. And that blended approach is recognized in the dicta because in particular in the Privy Council decision, the Samaraj decision, we looked to the application of 2 very important cases. One was the very famous case of Lienage versus the Queen, which is a case which really set out what the provisions ought to be in terms of independence and separation of powers. But secondly, again reflecting upon the Surat judgment. And let me put Surat into context today. In the Surat judgment, there was a challenge against the Equal Opportunities Tribunal on the allegation that there was a breach of separation of powers, and that separation of powers really ought to have been considered such that there was an insulation against the executive, and that members should not be appointed by the executive. And Baroness Hale was at pains to set out that not every court, that not every court was to be considered of equal measure. That specialist tribunals are perfectly well appointed to be structured in different mechanisms. And that really is a very important decision. That Surat decision reflected upon in the Sam Maraj case, which in that particular case was treating with the appointment or reappointment, an allegation for legitimate expectation for reappointment of someone who had served as an industrial court judge. And the Privy Council went into the propriety of having a blended approach. That is, your adjudication officers being appointed by the Judicial and Legal Services Commission, but other members appointed by the Cabinet of Trinidad and Tobago. This is no different. And therefore, there's ample and clear precedent and judicial consideration of the positions. But more importantly, in this case, there's a further distinction to be drawn in terms of law. Bear in mind that the Chief Adjudication Officer and Deputy Adjudication Officers, they're performing a function alongside a demarcation and survey officer only for so long as lands are being brought under this new compulsory system. There will be a point where they will no longer have to act. That point may be in the future, But the demarcation officer and the surveying officer, their job is solely to treat with the demarcation of boundaries. They present the survey information. They're bound by the land surveying legislation. When they present their demarcation data, their surveying data, it's presented to the owners or persons in dispute. They can agree before the adjudication officer or not. And if they don't agree, you then go through an appellate provision where you go to the land tribunal, and from the land tribunal you can go to the Court of Appeal, and from the Court of Appeal you can go to the Privy Council. So these demarcation and surveying officers who are appointed by the cabinet and whose terms and conditions are provided for in the bill that we provide now, where the CPO enters into the exercise, it's not true to say that these officers are ad infinitum. Terms and conditions are applied, but you certainly don't want to be prescribing a time limit in relation to these officers because the exercise is an ongoing one. In any event, the qualifications and prescriptions will be done in accordance with the legislation. But because there is a due process protection from the activities and submissions of the demarcation officer and surveying officer, there is ample proportionality in the structure that we recommend. And therefore, I cannot agree with my learned colleagues opposite as to this position or submission that we should change the structure and all of Trinidad and Tobago must fare the executive. That's just not on. That's hackneyed, to use the expression. That argument is a hackneyed argument. Mr. Deputy Speaker, may I ask what time I must end?
It's 7:10, and then you have 7:25 for your full complement.
Thank you very much. Is there a procedural motion? No. Okay, thank you. Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, there was a very interesting argument which which treated with the vesting provisions. And the member for Oropouche West raised that position, and again I compliment her for the research which was undertaken. It was evident in the quality of her contribution, and I enjoyed listening to her submissions today, as I did last week, on the Registration of Title to Land Act. And on this particular approach, Mr. Deputy Speaker, I want to say, I wish to join with the member for Diego Martin Northeast in saying, and I declare my interest here, as the Member of Parliament for San Fernando West, I am very much interested in settling the lives and interests of the citizens in San Fernando West. Yes, approximately 4,000 people live in squatting conditions in San Fernando West, yes, and have lived so for 60 years plus on state land and some on private land. And Mr. Deputy Speaker, I find it intolerable to listen to my learned colleagues say, take some more time. Is this the right structure? Why not now? When, Mr. Deputy Speaker, it's the same members opposite who put forward amendments to this Parent Act that we're considering today in this bill. Not once, not twice, but 3 times, and let it lapse. It was the member for Oropouche East, as Minister of Housing, wearing that portfolio, as leader of government business, that came to the Parliament on 3 occasions to treat with the security of tenure and how it is statutory tenants were provided with the opportunity. Madam, Mr. Deputy Speaker, I recall vividly when the member came to the Senate and I was debating that bill. And he said it was a simple bill and there was nothing in it. Not realizing, the honourable member, that he was dealing with a 3/5 right, a property right, because he sought to extend legislation without any form of consultation to the landlords as against the tenants. And such a flippant approach led people into jeopardy, Mr. Deputy Speaker, because when that bill lapsed, as it did, today the government is receiving entreaties from people who are saying, help us out on the security of tenure position, and we have to tell them, well, look, unfortunately, it lapsed in 2014, and the rights have therefore vested backwards, and we can't disturb those rights. But, Mr. Deputy Speaker, it went further. There was a very significant piece of law which I referred to last week, and I must refer to today because it arose in this debate, and that was what I call a fraud which was perpetuated upon the people in Trinidad and Tobago. And that was the State Lands Regularization of Tenure Miscellaneous Amendments Bill 2015. That sought to amend the State Land Regularization Act, Chapter 5705, and also the regulations concerning certificates of comfort, and to revoke legal notices 151 of 1999, 134 of 2000, 135 of 2000. Essentially, my learned colleagues opposite piloted in May 2015 a piece of law which said to Trinidad and Tobago, you heard the Honorable Prime Minister mention it earlier, that the opposition's cry under the leadership of the member for Siparia was go forth and squat. We'll find it and figure it out for you. That 23-page bill, Mr. Deputy Speaker, involved land descriptions of squatting areas to be rolled backwards so that you could get a certificate of comfort with no form of planning certification, with no declaration of area, just by name reference to areas. As I said last week, and I'll say again, Mount Dore, Mount Dore. Anybody squatting in Mount Dore is declared. No demarcation, no land structure, nothing. But worse yet, in the schedule of 23 pages, Mr. Deputy Speaker, as we hear members today talking about environmentally sensitive areas and people must not be there and how you could go on lands like that, in the schedule, Mr. Deputy Speaker, were environmentally protected areas. So I cannot understand how an opposition today could come and preach to the government and say, look after environmentally protected areas, when in their own legislation, which they debated to full vent and purpose in the House, passed it in the House. Member for Siparia spoke. Member for Oropuch East spoke on that bill. Not a word was said then because it was okay just to fool people, Mr. Deputy Speaker. And that is a tragedy for the people of Trinidad and Tobago. Mr. Deputy Speaker, we had a further position. We heard members opposite ask about
delayed exactly. What point you want to on it?
Just a few seconds ago, the Attorney General speaking out, we came here to fool people and so on. I mean,
Could just reword, member?
the bill as debated, considered, debated, and passed in the House of Representatives under the leadership of the Honourable Member for Siparia, then Prime Minister, under the hand of Oropuch East as Minister of Housing, perpetuated a fraud on the people of Trinidad and Tobago and abused the most vulnerable people in our society in the most savage way. I have so restated. Mr. Deputy Speaker, there was a question asked about 16 years versus 30 years in the amendment that we proposed, and I wish to clarify and put onto the record. We're seeking to take account of an error which occurred in the 2000 package, and that 2000 package was the real property, did not take care of the fact that the Real Property Limitation Ordinance, Chapter 5, Number 7, actually referred to 16 years and not 30 years. And therefore, it was wrong to make reference to 30 years, and we have therefore harmonized it back so that private lands adverse possession is 16 years plus, state lands adverse possession is 30 years plus. Few more points to address, Mr. Deputy Speaker. I want to treat with the issue of the IDB. I heard members asking, the Honourable Member for Oropuch East asked, tell us when, tell us how much, tell us what's going on. We heard the Honourable Member say, tell us that you're building the highway to Toco out of the purse of Trinidad and Tobago and not from the IDB. I want to put on record, the government is in discussions with the IDB right now for the Komuto development and for the Toco development, and in fact the Honourable Prime Minister met with the President of the IDB. And therefore the government's position is in sync and is in harmony with its commitment to use proper international matrices for borrowings so that we get best value for money. Secondly, the Honourable Member for Princestown spent a lot of time referring to a report of the IDB, the Inter-American Development Bank. It is the publication of May 2016. I pulled the publication, Mr. Deputy Speaker. Lo and behold, I have yet to find what my learned friend has referred us to. And more particularly, I'm alarmed at what my learned friend left out of the report. You see, in drawing the criticism of this government, hiding under the label that the report was published in May 2016, the honorable member forgot to tell us that the data was extracted as of 2014.
Under them,
Listen to this.
as usual, under them.
For the other three
Silence.
countries, information is pulled from strategies with end dates in 2013 and 2014. Mr. Deputy Speaker, let's go further. The report goes into country analysis. It goes through in the Caribbean, Barbados, and other territories, etc. It gets to Trinidad and Tobago. Listen to this. Paragraph 3.3 at page 18. In Trinidad and Tobago, the main land governance needs are overall policy coherence and performance of the land registration and cadastral information systems. Hear that. The main land governance needs are overall policy coherence and performance. It goes on. Trinidad and Tobago needs to stay in front of climate change and its vulnerability to its impacts, including increased risk of natural disasters. It goes on at page 20 under land governance at a glance to say this. Hear this. It deals with the history of Trinidad and Tobago, the government of Trinidad and Tobago, etc. Listen to this one. At one point, a comprehensive package of land policy reforms was drafted. It was abandoned in favor of a piecemeal approach in accordance with the political process for legal reform at the time. It goes on to talk about the Land Tenants Security of Tenure Amendment Number 2 Bill 2014. It says this bill lapsed. That's the one I referred to, piloted by the Honourable Member for Oropuch East. It goes on to say there was a move towards parcel index mapping and systematic adjudication, but as of 2005, it had not seen much progress. This leads to inefficiencies and market confusion. It then goes on to deal with land data and land information, and it says that there are additional land governance issues and challenges in Trinidad and Tobago that merit attention. But Mr. Deputy Speaker, it's not true to say that this report is a condemnation of this government. Far from it. It says in black and white that policy needed to be put together. So let me address the policy. Mr. Deputy Speaker, the government hasn't arrived here by accident to treat with these bills. It's in an interarching, coordinated development. Number one, it is rooted certainly to making sure that the people of Trinidad and Tobago can have land title and therefore exercise their wealth and leverage their title against mortgages and facilities to look after themselves. That's married in a promise that we made to the people of Tobago and Trinidad to solve the issues of adverse possession or the quieting of title where people own the land but didn't have the title to the land. More particularly, it's married into our policy for land development. We have put out an incredible initiative at the urgings of the Honourable Prime Minister, the Minister of Housing and the Minister of Finance, spoken to in our budget, where we tell people, come and build as part of the private sector, develop homes for people, sell affordable homes in a wonderful structure of tax write-offs and incentives. But you can't do that, Mr. Deputy Speaker, unless you have the land in your name to do that. You can't have a public-private partnership venture if you have nothing to bring to the table. Next thing, Mr. Deputy Speaker, in terms of policy and coordination, it is tied into crime and criminality. And when we say that we wish to follow the money and bring accountability to the people of Trinidad and Tobago once and for all, Mr. Deputy Speaker, as I urge my learned colleague from Tabakit, when we say follow the money and dry up corruption, Mr. Deputy Speaker, it is a fact that the repository of much of the stolen money in Trinidad and Tobago, much of the corruption in Trinidad and Tobago, much of the investment of the proceeds of crime is to be found in three places: cash, businesses, or land. And if you don't know who owns land, how they own land, the certainty of land, then you're wasting your time, Mr. Deputy Speaker. We in this country throwing barbs about who has which apartment in Tobago? 111 Tobago Plantations. Throwing barbs about that. Soon enough, 111 will be certainly settled, so you know who owns it, how and where, and who uses it in a land adjudication process and investigation of title.
Honorable Member, your initial 30 minutes has expired. You have an additional 15. Care to avail?
Yes, please.
Kindly proceed.
Thank you, Mr. Deputy Speaker. So, Mr. Deputy Speaker, the policy behind this position is critical. How does that relate, for instance, I mean, it is that very line of argument that I wish to use to clarify something that was said in the House a little while ago. Mr. Deputy Speaker, there was a little bit of a crossing of positions. The Honourable Member for Oropuch East raised an issue about the Integrity Commission, sought to distinguish his position, and then said on the floor that he was not named in any litigation concerning the Eden Gardens. But the Honourable Member did not tell the Honourable House that it is public knowledge that there is a warrant with his name on it concerning Eden Gardens. And I'm not drawing any inclination, I'm drawing a statement of fact onto the record to explain the position.
But you are a constable, you see a warrant.
Member.
So, Mr. Deputy Speaker, it is passing strange.
Overruled.
Thank you. It is passing strange for someone to try to hide behind such a thin veil of protection, because the whole country knows the arrangements. And more particularly, it was carried by the media asking the Honourable Member a square question. And the Honourable Member's attorneys having to write and ask a square question. So we can't pretend today that there are defences that are being put up.
I cannot have this member standing and talking this.
48, which standing order, member?
48-6, he's imputed improper motives.
Member, I overrule.
Speaker. So, Mr. Deputy Speaker, let me be clear. I am setting the record straight. The member introduced it. The member sought to distinguish it. The member sought to rise and clarify it and made a statement which bears no resemblance to the facts in the public domain that there is a warrant with the member's name on it concerning Eden Gardens. And I'm finished there, Mr. Deputy Speaker.
Mr. Speaker,
Deputy
I'm pleading
Speaker.
with you on 48-6.
Member, the mover of the motion is summing up, and he is making references to all the comments that would have been made in the debate. Overruled. Proceed.
Thank you, Mr. Deputy Speaker. So, Mr. Deputy Speaker, on the position of policy as reflected upon by the IDB. Mr.
Silence.
Deputy Speaker,
Proceed.
in fairness to my learned colleague, I am prepared to give way now and ask a question of the Honourable Member. Is it in the public domain that your name is on a warrant concerning Eden Gardens? Yes or no?
I want to, no, he's asking me, so he has given way. So I will not respond to him. And I want to indicate to you that I have no information, the police have no information, and you have no information that any matter the police is investigating is Eden Gardens. Because what happened, Mr. Deputy Speaker, but I'm still responding, he has given way.
Members. Right, members. Honorable AG, you have the opportunity.
Thank you. I wanted to be fair to my learned colleague. I asked a square question, he answered. And I accept his answer on the record. That is his answer. Yes, Mr. Deputy Speaker. You see, very often, one can be the victim of positions. I've given way to my learned colleague, and he's put his position onto the record. So there is no need to clarify after. But suffice it to say, the public knows what the public knows. Anyway, and perhaps the police know. Mr. Deputy Speaker, I want to raise something else as I'm dealing with clarification. Mr. Deputy Speaker, I want to bear in mind that the Land Adjudication Bill, Mr. Deputy Speaker, am I on cusp of the original time? 7:25, thank you. Mr. Deputy Speaker, Mr. Deputy Speaker, the land adjudication process inside of here treats with the movement of projects. Members asked opposite whether projects could be stalled. In fact, the member for Oropuch West asked about the position. I did say that there is a certain process to be followed when the land adjudication cycle begins. And let me clarify that. The process involves that there can be no registration under the other two laws, the Registration of Deeds and the Real Property Act, without the participation of the adjudication officer. Meaning, you have to tell him and let him sign off on it, not that the process itself is stayed. However, there's a germane issue here, which is to whether developments are stopped, whether positions of continuation of projects can actually happen. And permit me to address that by utilization of an example. And I'll use a very real example. We heard in the public domain on this weekend, members opposite, in fact, I believe it was the member for Oropuch East, say that the project at St. James, the construction of the apartments at St. James, which are adjudication, which are the subject of adjudication.
That was never raised in the debate.
Overruled.
And Mr. Deputy Speaker, I said I would use an example. There was a land dispute at the St. James project. There was someone by the name of Kwamina versus the Attorney General. They brought litigation against the HDC. And in that adjudication exercise, there was an argument of the right to light. The person who was living next door to the development said that the high-rises would block the light from that the person enjoyed at their home. And that issue of infringement of boundaries, of adjudication of boundaries, and in particular spatial rights, fell into position. I want to put onto the record, I pulled up the judgment of the Honorable Madam Justice Miradine Armorer, which was issued in 2015, and the Honorable Judge specifically cited the judgment of the Honorable Mr. Justice Ventor in 2008, and again as varied in 2009. And that project had an injunction only in respect of the continuation of going upward on one floor in one building of the four, which means that the entire structure could have proceeded unencumbered. And when you quiet title, you're able to quiet issues of fact now. Because there was a dereliction of duty on the part of the Minister of Housing, the member for Oropuch East, in failing to conclude that project for the whole 5 years that he was the minister. And when I listened to the Honorable Minister on the television saying that there was an encumbrance and he couldn't continue,
Deputy
that
Speaker,
is just not the truth.
48-1. That was never part of this discussion today.
So Mr. Deputy Speaker,
Okay, again, overruled, overruled.
Deputy Speaker, you see, Mr. Deputy Speaker, my friends opposite like to say things like the IDB report, like to say things like the Komuto Manzanilla, like to say things like you don't know you have a warrant out, like to say, but it's just not true, Mr. Deputy Speaker. And the truth is that you will see this, and it is incumbent upon us to explain the rationale behind it. And the record, Hansard record, standing as it does, same way judgments of the High Court stand as they do, as the Madam Justice Miradine Armorer matter in the HDC and Kwamina matter demonstrates, it's just not true. You know, the Americans have a very useful thing called fact checkers. Anytime there's a debate going on, there's a running stream of fact checking. I wish there was a similar facility in Trinidad and Tobago as it relates to some of the submissions opposite. Mr. Deputy Speaker, there's perhaps only one other point for us to refer. Sorry, my learned friend, the member for Caroni Central, asked two important questions. The Honourable Member asked about fraud and how that could be treated with, and he asked about the divisibility between land and house in the consequences where, in the example that he gave, there was a money lender situation. First of all, the matter of fraud is dealt with under the Registration of Registration of Title to Lands Act, which we dealt with last week. Fraud is dealt with inside of there. If there's an allegation of fraud, you have the mechanism to treat with it under that piece of legislation. Importantly, in the moneylender example that my learned colleague gave opposite a short while ago, there is no divisibility of a house and land in almost the vast majority of cases, because the maxim in law, as I'm sure Urupuch West will know, is quicquid plantatur solo cedit. Whatever is affixed to the land becomes part of the land. And that, of course, takes account of a huge part of our culture in the Mitchell and Cowie cases where we dealt with chattel houses, etc., and that brought about the Security of Land Tenure Act, etc. So there's a whole history behind this particular position. But in most circumstances, whatever you build onto the land, once it's affixed to the land and doesn't form the basis of being a chattel house per se within the definition of the considerations of Mr. Justice Hugh Wooding, as he was in the Mitchell and Cowie case, once you can't move the property, it forms part of the property, once it's fixed there. And in that particular scenario, the moneylender, obviously, if he was a moneylender, you've got to ask the question whether he was licensed as one, and secondly, if there was a mortgage in relation to the land, then that mortgage forms potentially security which can be exercised. But the genuine point of fraud, where somebody rules out and says to you, I'm going to sell your land because I have a charge, or I own your land and you don't really own your land. It's the same point that the Honourable Member for Urupuch West raised. That circumstance of fraud can be treated with under the Registration of Title to Lands Act. There is a process in the High Court and in the Court of Appeal structures to treat with that, and it is definitely a clear-cut scenario. So there is remedy provided, and I know the Honourable Member has raised this. It's the second time he's raised it, as he raised it in the debate last week without reviving that debate. Honourable Mr. Deputy Speaker, I think that I've essentially covered the issues raised by all members opposite. There's one matter of amendment that I wish to refer to. I've circulated an amendment. Clause 8 of the bill, unfortunately, as presented, just didn't read right. And there was an error in its publication. So if we look to Clause 8 of the bill, Mr. Deputy Speaker, it proposed an amendment to Section 10, and it asked for a certain formula to be put in. When that formula was applied to the Parent Act, it did not make sense because it required us to do as follows. Not less than 7 days before the demarcation of land in adjudication section is commenced, the demarcation officer shall give notice of intended demarcation in that section and the time and place in which it will begin, at least 2 daily newspapers in circulation, at least twice for 4 consecutive weeks. So you are asked 1 week before to do something for 4 consecutive weeks for a process which started a week after it began. So it didn't make sense. When we went back to the rationale behind the amendments, we recognized that instead it should be that you have 7 days instead of 14, and then we cleared up the language to include that it's 2 consecutive weeks and on the website, etc. So that'll make sense in the committee stage when we consider it. Mr. Deputy Speaker, this law is proportional. It has a legitimate aim. It is proportionate. It has, thank you, Honourable Prime Minister, it has legitimate aim. It is something which is well coordinated in the policy of the government. It is something which is long overdue. It is something which we should definitely bring into the corpus lexus of Trinidad and Tobago, and I ask honourable members for their support opposite, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Land Adjudication Act 2000 be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Land Adjudication Act 2000.
Leader of the House.
Speaker, thank you very much. Mr. Deputy Speaker, I beg to move in accordance with Standing Order 15.5 that this House sit until the completion of the business before it.
Honorable members, the question is that the House continue to sit until the completion of the business before it. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Mr. Deputy Speaker, in accordance with Standing Order 68-1, I beg to move that the Land Adjudication Amendment Number 2 Bill 2017 be committed to the Committee of the Whole.
Honorable members, the question is that the Land Adjudication Amendment Number 2 Bill 2017 be committed to a Committee of the Whole. All in favor say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Honorable members, I have received notice of an amendment to Clause 8. Therefore, can we group clauses 1 to 7 and clauses 9 to 20? I have the consent of
Something.
Carney Central, member.
Chair, we did not circulate any amendments, so we have given no notice of amendments except to say so in the presentation. I'm asking through you if the Attorney General would consider these amendments that we present, which are accommodatable in terms of language and additions and modification. They are not complex amendments.
Mr. Deputy Speaker, I'm really in your hands. I mean, we've sat on the order paper for 2 years now in relation to these bills, and the opposition has taken a course which they're entitled to do, which is to not debate the bills en bloc. I therefore find it a little untidy to be asked to consider amendments on a viva voce basis.
Chief Whip, in terms of the amendments, the procedure is usually that they would be circulated accordingly. And I'm hearing your member for Carney Central, but in terms of you being the Chief Whip.
Yeah, well, we had we actually asked for some consideration, but if the Attorney General, based on what he just said, we move on.
Right. So again, so we're doing it clauses 1 to 7, then we deal with clause 8, and then we go to clauses 9 to 20. So that's the agreement.
Clauses 1 to 7.
The question is that clauses 1 to 7 stand part of the bill. Urupuchis?
Yeah, can I intervene now? Yes. I'd just like to ask a question on Section 4, because we are dealing with 1 to 7.
Clause 4.
Clause 4. And to ask the Attorney General if at this stage we can just put on record at the committee level our request that the Attorney General reconsider the appointment of the demarcation officers to allow the appointment by another entity rather than the cabinet and the executive. For the record, could this be considered? It requires really another amendment to the Parent Act, just for the record.
Attorney AG.
I thank the honourable member for putting the position on the record. I think it's been well debated, and the examples upon which the government draws support have been put onto the record. Regrettably, the government is not in a position to accede to those amendments, and we stand by the bill as drafted.
Okay. The question is that clauses 1 to 7 now stand part of the bill. Those in favour say aye. Members, we'll go over it again. The question is that clauses 1 to 7 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 7 now stands part of the bill.
Clause 8.
Clause 8. The question is that clause 8 stand part of the bill.
Mr. Chairman, the government proposes an amendment to clause 8 in terms of the draft circulated. The rationale for this is to make sense of the time frame because there was an inadvertent complication which we have sought to improve by the amended language which we have circulated.
The question is that clause 8 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Clauses 9 to 20.
Clauses 9 to 20. The question is that clauses 9 to 20 stand part of the bill. Carney, Central?
Yes, if you look in the parent bill at 12.3, it reads any order for the payment of compensation or
I'm sorry to
expense.
interrupt both the chairman and you. Could I please just understand? Clause 12 actually relates to section 17 of the Act. Would you please clarify the specific section you're looking at? You asked to look at the parent Act.
Well, I think it is 12 from what I can see. Part 3, claims and demarcation.
So that's clause 9, which we've... So clause 9 refers to section 12 of the Act.
Right, okay. All right. Yes. And the clause I want to flag is 12.3. Any order for the payment of compensation or expenses made against the owner of any land shall create a debt and be a charge on such land. And I wondered if the AG would be willing to add as amendment, and shall be recorded pursuant to section 16(1)(f), because that is where any land is subject to any right, which is so and so and so and so that the debt would be recorded where the record of the land is kept.
Thank you. First of all, Mr. Chairman, to the honourable member, through you, the bill does not propose any amendments to subclause 3 of section 12 of the Act. So we'd be introducing an amendment to something which is not the subject of the bill. However, the creation of a debt and charge on land is a usual feature of our laws. It in fact exists in a number of pieces of legislation, the Municipal Corporations Act, the Water and Sewage Authority, etc. And there is no need to condescend to the manner in which the charge bites, because there is a registration exercise with respect to charges, and then there's a prioritization in law of charges which applies. So the law takes care of the priority and acknowledgement of charges. That is bolstered in particular by section 34(2) of the Registration of Title to Lands Act, which we dealt with last week, which ranks the priorities of charges, including debts of this type. So the Registration to Title of Lands Act coordinates with this and takes care of prioritizations under section 34(2) of that Registration Land Act.
The question is that clauses 9 to 20 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 9 to 20 now stands part of the bill. Honorable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Mr. Deputy Speaker, I wish to report that the Land Adjudication Amendment Number 2 Bill 2017 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that the House agree with the committee's report on the Land Adjudication Amendment Number 2 Bill 2017. All in favor say aye. Aye. Any against? The ayes have it. Attorney General.
Mr. Deputy Speaker, I beg to move that a bill entitled An Act to Amend the Land Adjudication Act 2000 be forthwith read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Amend the Land Adjudication Act 2000 be now read a third time and passed. All in favor say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Amend the Land Adjudication Act 2000.
Attorney General.
Mr. Deputy Speaker, I have just to grab my notes for the next bill, if it will please you. Perhaps I should just start with the procedural points. Mr. Deputy Speaker, I beg to move that a bill entitled An Act to Amend the Land Tribunal Act 2000 be now read a second time. I will endeavor to shuffle my papers quickly to the other batch. Forgive me, Mr. Deputy Speaker. And I thank God Almighty that I practiced in conveyancing for as long as I did, so that at least I could treat with these bills as quickly as I can. I need no help from Oropuch East on anything, warrants or otherwise. Mr. Deputy Speaker, the bill before us is relatively straightforward. The bill is anchored in 8 short clauses which treat with an amendment to the Land Tribunal Act 2000. The Land Tribunal Act itself is an act consisting of 18 clauses, 18 sections under 5 parts. In the package of laws that we ask this Honourable House to consider, we are asking for the bring to life of a brand new system of legislation as it relates to land. I'm obliged, Mr. Deputy Speaker, insofar as we are debating bills on a separate piece-by-piece basis, albeit related logically and operationally so, I'm obliged to put on record in anchoring the legitimate aim of the bill the following provisions, which my learned friends opposite will no doubt remember well from the debate which was just concluded and that which was held last week. The system of land law in Trinidad and Tobago is born out of an inherited position of law which we took from the United Kingdom. In the United Kingdom, we received laws in the 1900s, in the position 1892 in particular and 1874. In 1874, we received the Registration of Deeds Act. In 1874, we saw birth to the Registration of Deeds Act as chapter number 1906. It was soon after that, in 1845, where that Registration of Deeds Act came in, that we saw the annex of Tobago, and if I'm not mistaken, it was in 1886 or 1889. Tobagonians can correct me, as I stand slightly incapable of remembering whether it was the 6 or the 9. I think it was 1889. But post the annex of Tobago, Trinidad and Tobago came upon a system of asking for a simplification of our titling system. The difference between the Registration of Deeds Act and the law which was then brought to Trinidad and Tobago in the year 1892, which was the Real Property Ordinance, was that the Registration of Deeds Act allowed for the recording of transactions between individuals. Those transactions could have included the subject matter being land, but the transactions under the Registration of Deed Act did not and cannot include any certification of the subject matter, which was land. To do that, under the Registration of Deeds Act, a system of law grew up where an investigation of title had to be performed. And that investigation of title, in what we refer to in Trinidad and Tobago as the old law system, that investigation of title involved going backward in time from a current transaction, finding each of the participants who treated with the subject matter, the land. So let's say there is an agreement, there's a deed between the member for Pointe-a-Pierre and myself in respect of a piece of land, and it referred to a particular piece of land as described in the schedule, and the schedule referred to another deed. You'd have to go and find the other deed, then go back and see who those parties were, check the schedule, find the other deed, and work your way backward in something which is called titling. In the real property world, under the old law system, you are obliged to go back until you get to what is referred to as a good root of title. And a good root of title includes instruments such as a mortgage, a conveyance, and for value, or where you come down to a deed of gift, and they rank them in priority, with some being of less strength than others. Once you got to a root of title, which is usually around 30 years, you then work your way back up from the root of title to the current transaction, and then you certify via a lawyer what the transaction looks like in terms of the subject matter. Did the member for Pointe-a-Pierre, in the example I just gave, does he in fact own the property? Was it subject to a mortgage? We have example, the property, was that deed of gift correct? Was the conveyance properly done? Were there any judgments, etc.? So this system of looking at the subject matter under the Registration of Deeds became very, very messy and is quite complicated and indeed expensive. On average, a search can cost a couple of $100 if it's a very simple search, or right up to a few $1,000s when you're looking at it. And the purchaser, as a rule of thumb, looks to the title and searches the title to make sure that the maxim of law, caveat emptor, prevails. Buyer beware, because you've got to check your title. In 1892, the Real Property Ordinance came around, which was an importation from Australia of what is referred to as the Torrens system, so named after Lord Robert Torrens. And in 1892, the transactional formula from Australia came to Trinidad and Tobago. It was applied then as a British Crown colony, and the subject matter involved the transactions of land being treated with under something called a certificate of title. That certificate of title was done in counterparts. There was one held at the registry, and there was one held in the hands of the owner or mortgager, as the case may be. On the back of the certificate of title, there was a system of memorials. There would be an endorsement on the back which says, member for Pointe-a-Pierre transferred property to San Fernando West, check volume so-and-so, folio number so-and-so, and you go and you look for it. There was a mortgage, there was a deed of gift, there was a mortgagee sale. All of this was put onto the certificate of title, one copy held at the registry and another copy held at the, in the hands of the person who owned the property most usually, or the mortgager. What happened next is, unfortunately, the phenomenon of non-fulfillment set in the RPO structure. The RPO, which became the Real Property Act, involves a system of voluntary registration. And unfortunately, only about 20% of land value in Trinidad and Tobago found itself under the provisions of the Real Property Act. Trinidad and Tobago went through an experimentation beginning in the year 1977 in considering amendments to the land system package. We looked at various Commonwealth jurisdictions. In looking at the Commonwealth jurisdictions and the Caribbean Commonwealth jurisdictions, a land package was developed by Professor Wiley in 1981, which comprised a suite of legislation, including the Landlord and Tenant Act, the Succession Act, the Condominium Act, etc., all of 1981. That package was never brought into law because the system, which was based on the Guyanese model, didn't quite operate well, and there were significant concerns amongst the stakeholders and users that it would be too costly and too alien a structure to introduce into Trinidad and Tobago. Fast forward into 1998, into the year 2000, 1999, 1998, there was a revision of the purpose, and we looked at a further system of comparative jurisdictional experience, and the 2000 package was implemented by Attorney General, the Honorable Ramesh Lawrence Maharaj, introducing a package of laws into this Parliament, one of which is this particular bill. That package of laws articulates as follows. 1, the Registration of Title to Lands Act. 2, the Land Adjudication Act. 3, the Land Tribunal Act. And those 3 pieces of law formed a cohesive matrix to improve the registration of systems. The model for the Registration of Title to Land Act was in fact the Real Property Act. Instead of it being voluntary, it was cleaned up and made to be a compulsory system so that you would engage in an entire exercise of identifying every piece of land in Trinidad and Tobago and bringing it onto a system of registration through a land adjudication process, which in fact we just debated a short while ago, where a land adjudication system was set up to make sure that persons that agreed to have lands registered or objected to have lands registered could have their concerns ventilated in a system which was attuned and attenuated to the culture of Trinidad and Tobago, a philosophy for agreement, cooperation, and even objection. The third limb to this law which applies is the mechanism for the tribunal. Registration on a compulsory basis of all land in Trinidad and Tobago is one law. The adjudication process is dealt with by the Adjudication Act. That Land Adjudication Act has a process where a land adjudication officer, chief land adjudication officer, operates with other adjudication officers. Demarcation officers and survey officers go to work on the land, identify the surveying for the land, feed it into the chief adjudicator. The chief adjudicator then considers whether an absolute or provisional title should be granted in respect of state land or private land, but there needed to be a mechanism where in the event that there were disputes or need for clarification or ventilation of rights to be considered, a tribunal approach was adopted to consider these positions. And I thank the honorable members for allowing me to reflect that Tobago became a ward of Trinidad in 1899. So I've got that date correct. So land registration, land adjudication, but the inevitability of disputes had to be factored. And so the land tribunal came about, and the land tribunal legislation became part of the laws of Trinidad and Tobago in the year 2000, but they were not in fact proclaimed. And these 3 laws that I've just spoken to were not proclaimed because, again, there were the difficulties in how the operationalization should happen. There was a lot of stakeholder opposition. The legal fraternity, general public felt that the system needed to be better ventilated, that there should be better education, and more particularly that the resources for the operationalization from a state provision of resources perspective had to be cemented. Mr. Deputy Speaker, when we look to the Land Tribunal Act, as this bill proposes that there is an amendment, this act actually falls under the auspices of the Attorney General, whomever holds that position in Trinidad and Tobago. And it is this act, the Land Tribunal Act, which completes the land package. This act provides the avenue for appeal against decisions from the land adjudication process, which is in the Land Adjudication Bill, which we just dealt with, and the Land Adjudication Act. And it is this particular position that allows time limits and jurisdictional limits and other matters to be treated with. Again, the precedenting factor for this was found no further than the Commonwealth Caribbean. The Land Tribunal Act, as it is divided into the 5 parts of the Act, really is a very simple piece of law. The Act itself has a preliminary section. It then deals in Part 2 with the establishment and jurisdiction of the Land Tribunal. Part 3 treats with appeals. Part 4 with administration, and Part 5 miscellaneous provisions. The bulk of the bill that we have before us today really treats with constitutional issues as it relates to Part 2 of the Parent Act. And those constitutional issues anchor as deep as in the establishment and jurisdiction of the Land Tribunal. In the 2000 Act, Mr. Deputy Speaker, the tribunal was to be known as the Land Tribunal. It was designated as requiring composition of a chairman, a deputy chairman, and other members appointed under the section. The chairman and deputy chairman, could I ask for a little quiet, Mr. Deputy Speaker? Constant murmuring.
Yeah, members, I think there's some pockets of chatter going on. Please desist so that we can hear the Honorable AG. Proceed.
Thank you, Mr. Deputy Speaker. In the position of the law as it stands, without this bill coming into effect, the establishment and jurisdiction of the Land Tribunal, in that structure, the members, the chairman and deputy chairman, were to be appointed by the Judicial and Legal Services Commission. They were to be attorneys at law of at least 10 years' experience. But the law went on to say that other members not exceeding 6 in number shall be appointed by the President from among persons appearing to him to be suitably qualified by virtue of knowledge and experience. Now, it then flowed on to the chairman and deputy chairman appointments for 5 years on such terms and conditions, and that the quorum was to be 4 members, including the chairman or deputy chairman and 4 members. It then went on to say the decision is to be by majority vote, and then it went on to speak to where the chairman needed to provide members, and that terms and conditions of temporary members could be applied as well. That formula contained in Section 3 of the Parent Act, as a result of decisions coming out from the Privy Council, in particular in the case of R.V. Hines and the dicta of the Privy Council, it is standing today in the position where it is rendered unconstitutional. And it is rendered unconstitutional under the R.V. Hines formula because there was not enough insulation from the executive by polluting the appointment of other members of the tribunal alongside of the chairman and deputy chairman. And that is so because this Land Tribunal, although not expressly provided in the Parent Act, is intended to act as a court of superior record. Therefore, recognizing the unconstitutionality post R.V. Hines, and indeed post other considerations by the Privy Council and our own Court of Appeal, the government amended and brought today amendments to this bill, to this act via this bill. And in our amendments, we start off in the Clause 4 of the bill by inserting an entirely reformulated version of the tribunal. And the tribunal, as we propose now, stand part of the laws, if this bill is accepted by this Honourable House, will specifically state that the tribunal is established as a superior court of record, and that it shall have, in addition to jurisdiction and powers conferred on it by the Act, that it shall have the particular provisions set out in the law. Mr. Deputy Speaker, in the bill before us, in the Clause 4, which proposes the amendment to Section 3 of the Parent Act, we are asking that the appointment be the same as prevails under the constitutional arrangements. We are asking that the chairman and deputy chairman and 4 other members who should also be attorneys of law of at least 10 years experience and practice in land law shall be appointed by the President on the recommendation of the Judicial and Legal Services Commission. We specifically, therefore, provide a replication in the statute as amended, as proposed to be amended, as you would find in the very language of the Constitution in Section 104 of the Constitution, Section 104.1. Mr. Deputy Speaker, we propose specifically to insulate the members of the tribunal by applying the direct provisions of the Constitution, and in particular the sections 104 to 107 inclusive of the Constitution. We direct that they apply to the appointment of members of the tribunal, and 104 to 107 traverse, that is the Constitution of Trinidad and Tobago, traverses the qualifications for appointment. Very importantly, in 106 of the Constitution, that a judge holds office subject to sections 136 and 137 of the Constitution. 136(6) of the Constitution says, very importantly in terms of insulation of judicial officers and bolstering the separation of powers argument, that you shall not derogate from the terms and conditions to the negative effect of judicial office holders. In other words then, you cannot alter their terms and conditions to their detriment. 107 requires the oath of office. 136 goes in fact a little bit further, that says you can't in fact abolish an office if there's a sitting judge in it. So we are incorporating in the new subclause 3 of section 3, as proposed to be amended of the Act, the entrenched provisions of the Constitution as it relates to separation of powers. This separation of powers principle is the very hallmark of the Westminster system of government, where the executive, the legislature, and the judiciary are kept apart from each other. But as recognized in umpteen judicial pronouncements from the Privy Council come down, there is a certain fluidity, be it in Cooper versus be it in the DPA versus Cooper, be it in the dicta coming out of the umpteen cases on the Police Service Commission or Teaching Service Commission. We definitely are taught by the dicta coming out of the Privy Council and our own Court of Appeal that there should be a fluidity of purpose between the 3 arms of state as we have. So it is not quite to say that there is a strict separation. It is on the back of that argument that the appointment of the other members of the tribunal stand quite proper before us. Because in the fluidity arrangement, this bill proposes that the other members of the tribunal be appointed by the President. So we look to the new subclause 4. The chairman, deputy chairman, and other members of the tribunal shall be appointed on such terms and conditions as shall be fixed by the President in accordance with Section 3B. Section 3B speaks to, as we go further down into the bill, the terms and conditions, allowances of members of the tribunal, etc., salary and remunerations. So let's treat with that first of all. There is further structure. It is true, and the government acknowledges, that pursuant to Section 74(1) of the Constitution, that executive authority is exercised by the President. Section 75 of the Constitution establishes the Cabinet, which has executive management. But Section 80 of the Constitution forms a fetter to Section 74 of the Constitution, because the President must act in certain circumstances, either as directed by the Cabinet, so to put it, or in his own discretion, or after consultation with certain entities, for instance, a Prime Minister and Leader of Opposition. But the provision of the President being equal to Cabinet, and Cabinet providing terms and conditions, is a feature of our laws. This bill proposes, as I've referred to in the new subclause 3B that we insert, that there's a further degree of constitutional protection, because the bill proposes the prescription of 2 very important things. Number 1, in clause 3B, as it is proposed to be amended by way of an insertion into the Parent Act, that the terms and conditions shall be determined by the Salaries Review Commission in accordance with Section 141 of the Constitution. And again, that forms constitutional protection for the arrangement of insulation away from the executive, because the SRC as a service commission is insulated from the executive and constitutionally entrenched in its method of protection. Mr. Deputy Speaker, 3B subclause 2 goes a little bit further because it replicates the provisions of section 136(6) of the Constitution. And 3B subclause 2 reads as follows: the salary, remuneration, allowances, and other conditions of the chairman, deputy chairman, other members of the tribunal, and lay assessors shall not be altered to their disadvantage after their appointment and during their tenure of office. That, Mr. Deputy Speaker, forms a very critical protection for the structure of the tribunal. And, Mr. Deputy Speaker, it therefore stands as positive statement of constitutional purpose. I wish to offer, by way of further comfort to the honourable members of this House, that the judgment of the Honourable Madam Justice Paula May Weeks, Justice of Appeal, as she then stood, delivered on the 9th of December 2014 in Civil Appeal number P129 of 2012 in the case of Paul Lai, LAI versus the Attorney General. We traversed very important dicta standing as well-known reference points for law in Trinidad and Tobago and the understanding of law. In particular, we traversed the dicta coming out of the Privy Council's judgment in the Surat case. And permit me to read into the record, coming from page 20 of 55 of that judgment, the following. The Privy Council's material findings are accurately reflected in the head note as follows. The Constitution contemplated that judicial bodies other than the High Court might exercise judicial power of the state. 2. Since most complaints heard by the Equal Opportunities Tribunal would not overlap with Section 4 and 5 of the Constitution, and those which did were subject to the rights of any party to request a reference to the High Court under Section 14(4), the Tribunal's jurisdiction did not significantly derogate from that of the High Court. And 3. The Tribunal's limited and specialist jurisdiction was not such that it had to be exercised by a judiciary enjoying exactly the same protection as the High Court judge, and its chairman and lay assessors had sufficient protection for their respective roles by way of tenure and protection from removal, albeit not entrenched, so as to afford the necessary degree of independence from the legislature and executive. That is directly relevant to this debate. But the distinction poured upon the positions espoused by the Honourable Madam Justice Weeks, Justice of Appeal, is to be found in the fact that we have not stopped, as the Surat case did, by not providing constitutional protection. We have anchored it into the amendments to Section 3 of the Act in the manner that I have described, by invoking the provisions of Sections 104 to 107 of the Constitution, by invoking the aid of Section 136 and 137 of the Constitution, by invoking the aid of Section 141 of the Constitution, and by relying upon the regularity of the President pursuant to Section 80 of the Constitution being directed in the fashion that the Cabinet suggests as set out in Section 75 of the Constitution. So constitutionally, we are in good purpose. Jurisprudentially, we are in good purpose. And so stands the dicta of our own Court of Appeal, which affirms the decision of the Privy Council in several judgments. Mr. Deputy Speaker, the amendments proposed in Clause 5 of the bill really treat with how the amendments flow as a further cautionary regard. Clause 5 of the bill provides for the recusal provisions, where the chairman has a pecuniary interest, direct or indirect, in any proceedings. The clause proposes that there is a recusal and step away from decision making. Where other members find themselves in conflict of interest, we also prescribe against that. And therefore, we are laying a further protection against this superior court of record in a specialized arena as it functions, to be insulated from executive authority, but more so from arbitrariness, bias, or conflict of interest. When we look to Clause 6 of the bill, we are proposing that there be amendments to Section 5 of the Act, In Section 5 of the Act, Mr. Deputy Speaker, if we look to the Parent Act, we are proposing that we delete one of the provisions, and Section 5 of the Act deals with the jurisdiction of the tribunal. This bill proposes a broadening of the jurisdiction of the tribunal to allow us to now say this tribunal can hear and determine appeals of adjudication officers. It can review any recording, cancellation of recording, any revision of registration, decision of the registrar under the Registration of Titles to Land Act, and direct any corrections. It can hear a claim for compensation under the Registration of Title to Lands Act. And we've added now in subclauses C through G inclusive to declare a provisional title as absolute for the purposes of Section 16.3 of the Land Adjudication Act, to hear and determine applications relating to adverse possession of state lands and private lands, to make vesting orders, to give directions to the registrar under the Registration of Title to Lands Act to record a title in the land registry, and G, to hear and determine any other matter that may be assigned to it by order made under Section 12. Of course, jurisdictionally, the section in the Parent Act goes on to say that any appeal or claim in subsection 1 shall be as of right. Mr. Deputy Speaker, in the round, therefore, this bill proposes an amelioration along constitutionally prescribed parameters. It takes account of the developments in the law in the period 2000 to date. It calls in aid the specific terms and conditions of the Constitution, which is described in Section 2 of the Constitution as the supreme law of Trinidad and Tobago. It treats with conflicts of interest. It treats with recusals. It broadens the jurisdiction of the tribunal, therefore allowing for an amplification of its work, which is akin to the inherent powers which the court ought to have. I can't use that term strictly, but what I can say is that with the broad description of any other matter falling within the jurisdiction, that we have now broadened in a safety net mechanism the jurisdictional powers of the tribunal. Mr. Deputy Speaker, this is good law. This is the missing element which must work alongside the Registration of Title to Lands Act and the Land Adjudication Act. I welcome the submissions of my learned friends opposite. I think that it is a rather straightforward matter, but the government is, of course, interested in hearing the submissions of my learned colleagues opposite, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that the bill entitled An Act to Amend the Land Tribunal Act 2000 be now read a second time. Recognize the member for Urupuch East.
Thank you. Thank you very much, Mr. Deputy Speaker. I rise to make a contribution on the matter before us, which is the amendment to the Land Tribunal Act 2000. Mr. Speaker, this is not, of course, the first time for the day I would rise, so I'm in mortal fear that for the rest of the night I'll be here in Urupuchis, from San Fernando West and from Diego Martin West. But so be it, Mr. Deputy Speaker. Mr. Deputy Speaker, the matter before us, of course, forms part of a wider menu of it's 4 pieces. So it forms part of a wider menu of our package dealing with our land law and land management. It is also, Mr. Deputy Speaker, because we are debating these matters separately by choice. The last time we chose to debate matters together, a debate fell down. And after that experience, we are very wary of any agreement to debate bills together, as related as they may be. Mr. Deputy Speaker, it means, of course, we must then put on record some of the issues surrounding this legislation, this piece of legislation. Mr. Deputy Speaker, without getting and repeating the history again, it's very clear that this matter forms part of the package that was passed in 2000 by the then United National Congress administration. Like other pieces, it has not been implemented. So what we are doing is seeking to amend a piece of legislation that was not implemented to make it better in the event that it is to be implemented. However, Mr. Deputy Speaker, we have the same concern that this matter has been there for 18 years now. The government is very eager, and the Attorney General noted that when the last administration was there, I think on 3 occasions it was on the order paper and then lapsed. It was on the order paper in this administration, the 11th Parliament, once and lapsed. So it is a matter that has been around for some time. And the passage of this, the message here very early, is the passage of this amendment bill in no way guarantees that this will be given effect to. In no way guarantee that we will ever, in the foreseeable future, implement it. The implementation part is a completely different ballgame. And in this particular measure, at least, implementation is more critical because of the very nature of this bill that gives rise to a new administration, a new division, and a significant part of that. And I wanted to continue that analogy with the industrial court and industrial tribunals. In some parts of the Caribbean, you do not have industrial court, you have industrial tribunals. And they are set up in some way, mirroring the setup here. Now, this setup was introduced in the year 2000. We are now into amending. But it was set up in 2000. And again, the amendments now seek to make some fundamental changes, which we will get to in a few minutes. But there are some very important questions in terms of the operationalization of this. And one of the reasons that members on this side proposed early o'clock, so to speak, that it was a matter that we could have sought to get more views on and have consultation on, is whether or not a proposal in 2000 amended in 2018 is still relevant to the needs of our time. Because implicit in what is being said, and particularly the member for San Fernando West, the member for San Fernando West in his presentation, regale us with his knowledge of the numbering of the Constitution, 78, 85, 136, 137, 104, 107, I think. All of that sounds nice, but there are operational issues that you must reflect on. Not just Hines and Surat, but there are issues that we must reflect on from the point of view of how are we going to operationalize this? How is it going to work? We are clear on what it is about, the criteria that we want to give effect to. What we must be clear on, how will it work? For example, I will give one example to start. The Attorney General took us through the amendment bill and the key areas he took us through. And I'll just point to one, and I'll come back to it later, but just to start the argument off. For example, at Clause 4, you are repealing the entire Section 3 of the parent bill. And you're confirming by Clause 4, Item 3, so to speak now. So it is an amendment called, is the provision, Clause 4 of our amendment bill, but it is 3.3. Sections 104 to 107 of the Constitution shall apply to the appointment of members of the tribunal. When we look to our Constitution, when we look to our Constitution and we look to 104 to 107, Mr. Deputy Speaker, it speaks to the issue of appointment of judges, of justices of appeal and puisne judges, and the appointment of judges. And this is done through a process in the Constitution through 104 to 107 that deals specifically with the role of the Judicial and Legal Service Commission and the use of the criteria of the JLSC, as it is called, acting in, that the Chief Justice shall be appointed by the President. The judges other than Chief Justice, so to speak, shall be appointed by the President in accordance with the advice of the JLSC, and then spell out all the procedures to be followed and the qualifications. of judges, and so on. But in saying that, we are saying that we are happy with the way our judges are appointed. Are we happy with the way judges are appointed to begin with? Because we are bringing an amendment bill to Parent Act, the Land Tribunal Act 2000, to use the same part of the Constitution for the appointment of judges, for the appointment of members of the tribunal, in the belief that we are very happy the way things are going with the appointment of judges. And, Mr. Deputy Speaker, this was the opportune moment for the government, or for any government, to reflect over the appointment of judges, to reflect over that procedure. Because, Mr. Speaker, it goes without saying that all is not well in the state as it relates to those issues. And I just want to make one reference to an article published on May 6, 2017. Mr. Deputy Speaker, it is I believe it is the Guardian, the Trinidad Guardian. And it is an article, and I quote, "Justice Gobin, make judges' appointment more transparent." And
Remember,
yes.
again, the bill we are debating is an act to amend the Land Tribunal Act 2000. It's not on the judiciary, it's not on the judges. So again, tie in your point quickly, and if there's anything, move on to the other point. Okay?
My point, Mr. Deputy Speaker, and I'll just repeat it because I really would like you to approve my approach. At provision 4 of our bill, it states that members of this land tribunal, hereby established, will be appointed pursuant to section 104 to 107 of the Constitution. That is in the matter in my hand, on my right. That is the approach to the land tribunal which we are dealing with. So to understand how they are to be appointed, we have to go to the Constitution. Because there's a reference there. The drafters of our amendment bill tell us, look to the Constitution. So we look to the Constitution, and that has to do with the appointment of judges. And I have the Constitution in my hand here. 104, appointment of judges, and that goes to 107, qualifications of judges, term of office. So I'm not reflecting on judges. I'm reflecting on the procedure used to appoint judges. Because it is a procedure we have now captured and placed in our amendment bill. I don't know if you follow me totally. We have captured that from the Constitution, placed it in our amendment bill, so I'm reflecting on that. It is not the judges themselves, it is the procedure by which they are appointed. And I'm saying, in the realm...
I hear you, member, but I'm saying tie it in quickly and go to the next one. That's all I'm saying.
Okay, sure. I will fast forward the point then. And the point is simply this. There are serious questions in the national community about the secrecy, the lack of transparency, the problems associated with the appointment of judges using that procedure that the Attorney General recommends us to use. I think that's the fastest way I can say it. Yeah. So the procedure being recommended for us to use, in some quarters, it is regarded as a poor procedure. Now, we may not have a better procedure, but it is not the best because there have been complaints by members of the national community that what we are proposing in clause 4 of our amendment bill, and it is to be the new section 3, and I'm looking at 3.3, there are commentators who believe that that by itself is inadequate. It is counterproductive, and it is not in the best interest of good governance. And we are taking that and saying, let's appoint the tribunal. So let me stick to our amendment bill. I just want to read clause 4 because I have some other queries there. This act is amended by repealing section 3, and I have the parent bill in my hand as well, Mr. Deputy Speaker. And I have, of course, section 3 of the parent bill before me. It is called Establishment and Jurisdiction of Land Tribunal. So a tribunal to be known as the Land Tribunal is hereby established, which shall be a superior court of record and shall have, in addition to the jurisdiction and powers conferred on it by this act, all powers inherent. Right. The tribunal shall comprise of a chairman, deputy chairman. What is that noise, Lavantil West?
Members, hold on. Members, this is the third time. Members, this is the third time. I'm on my legs. This is the third time that an electronic device has gone on in the chamber. Please ensure that your devices are on silent or muted accordingly. Right, this is the third time. So I've taken note. Proceed.
Thank you, Mr. Speaker. It was extremely disturbing, member for Laventille West. And I forgot my train of thought when I heard that loud explosion. Mr. Deputy Speaker, the tribunal comprised of the chairman, deputy chairman, and 4 other members, all of whom shall be attorneys at law of Trinidad and Tobago of at least 10 years' experience in the practice of land law, and who shall be appointed by the President on the recommendation of the Judicial and Legal Service Commission. That is now before us. Now, Mr. Chairman, Mr. Deputy Speaker, in the Parent Act, it says now, the tribunal shall comprise a chairman, a deputy chairman, and such other members appointed under this section. The chairman and deputy chairman shall be appointed by the Judicial and Legal Service Commission, shall be attorneys at law of Trinidad and Tobago of at least 10 years' experience in land law. The other members, not exceeding 6 in number, shall be appointed by the President from among persons as appear to him to be suitably qualified by virtue of their knowledge and experience in the various disciplines necessary for the implementation of this act. There's a question here, and I say tonight I want to raise some operational issues, some issues of interpretation. I know when we do this, members opposite feel we're not supporting, we're betraying, and at worst we are unpatriotic because we dare raise questions. But our job as the opposition is to raise questions. That's our job. And seek clarity on behalf of citizens. And seek clarity on behalf of ourselves. So, Mr. Deputy Speaker, in the Parent Act, they said the President appoints from among persons as appear to him. That appears to him. So there's a suggestion in the Parent Act that the President will appoint in his discretion. Or if the advice is coming from the Cabinet, he can, or she, as the case may be, can reflect whether the persons are so suitably qualified and so on in the Parent Act. That has gone because that has been repealed. And we are now saying chairman, deputy chairman, and 4 other members, all of whom shall be lawyers. So in the initial Parent Act, 2 lawyers, chairman, deputy chairman. In this act, in this amendment, 6 persons are to be chosen as the tribunal. All shall have 10 years' experience in practice of land law and appointed by the President on the recommendation of the JLSC. And Mr. Deputy Speaker, all should be attorneys at law and practice in land law. Now, the first thing I've been asking colleagues, and I need some clarification on this, is that when we use both in the Parent Act and in the Amendment Act, practice of land law, is it that the JLSC will consider attorneys at law, 10 years experience, of course, but how do they establish that persons have been in this practice? Because clearly there is no registry of this. So you will have to have some type of, understanding of what persons have been doing for many years, whether they have been in this field, whether they have not been in this field. Because how it works is somebody will be in the civil court and they do a little bit of everything. They may do a little bit of everything. And 1 year pass, 2 years pass, you're doing something in employment, then you shift to something in civil tort, then you shift to something in land, then you do that. So it is being left to the Judicial and Legal Service Commission to exercise what I believe here to be almost a judgment, some interpretation of attorneys at law who practice land law. Now, in the discipline, I think there's an understanding of a few key players in the country who have been doing this and in this practice for a long time. We know a few names. It is unlikely that persons who have spent all this time and have their business worked out and so on will be attracted, given terms and conditions in public service, which I'll come to in a little while. So, again, it ties into the point I'm making, is that we already have complaints about that procedure used by the Judicial and Legal Service Commission. And now we are telling them, we are very happy with what you are doing, use more discretion. When you appoint people now, use more discretion, because there is no registry of persons who practice land law. So you will have to determine as the JLSC. We are giving them that power of latitude, of discretion. Consider anybody who you know and, 10 years. Well, 10 years you establish easily. But you are practicing in this area. And as I said, very few are experts in the area. It is an area people, attorneys talk to me, it's an area people run from, to be honest. Very few people would dedicate their entire career and practice in this area. So many will practice in several areas, which may or may not include land law. So there's a problem that will start there. And I raised that matter with the Judicial and Legal Service Commission. And taking the persons that way. And all our 10 years of experience, at least 10 years, so it could be more, and putting it in the formula of the Constitution, which we are not sure is proper, and we are sure that there are conflicting views on that procedure for the appointment of judges, which we are taking. Let's go further. The chairman and deputy chairman and other members of the tribunal, so far we're only talking about the lawyers, shall be appointed on such terms and conditions as shall be fixed by the president in accordance with 3B. 3B deals with terms and conditions and allowance of members, and this is again another legislative hook. It hooks on to section 141, which is the Salary Review Commission. So we are going to say our chairman, deputy chairman, and 4 other members, attorneys at law, 10 years practice in land law, and their terms and conditions by Salary Review Commission. Now, what could go wrong with that? We just had a major public conflict of all types. The Prime Minister used the term a looming constitutional crisis over a report of the Salary Reviews Commission. So we're going back to the Salary Reviews Commission. And again, I want to put the point that this will take time. This takes time. So this thought that you will pass something and by the end of this year, something is operational and we have a land tribunal will not work like this. The Salaries Review Commission will take some time. They have to undertake studies, they have to undertake, assessment, they have to undertake what is called job description, and what is called comparative jobs analysis and so on, to see who or what these people can look like. Because so far we are only with the lawyers. We haven't reached elsewhere yet. So we are only with the lawyers. So there are terms and conditions to be determined. Now, the Land Tribunal has the same standing of a Superior Court of Record, the High Court. Is it that those persons who are to be appointed as tribunal members, they are attorneys at law, and they satisfy, I think, the qualification for a High Court judge, 10 years, are they on the same terms and conditions of High Court judges? Because if they satisfy that qualification, the tribunal is a Superior Court of Record to be determined by the Salary Review Commission. The Salary Review Commission, Mr. Deputy Speaker, also determines the terms and conditions of what is called the higher judiciary. And that's where the conflict was the other day, over that interpretation. So, is it that the terms and conditions of these members who are akin to a High Court judge will be that of the High Court judge? That is an interesting question. Now, we cannot say that because it is for the Salaries Review Commission to determine that, not for us. Let's continue. Well, the salary remuneration allowance cannot be altered, but that's a kind of simple thing enough to understand. And we have now the criteria. Another criteria emerges now, and I think this is the crux of their amendment. And you see, when you say that we did not debate it for 3 years and things, it is not that we forgot or we fell asleep or something, There were still concerns with these matters. You see, Mr. Deputy Speaker, those on the other side stand up and say it was on the order paper in the 10th Parliament 3 times and we didn't debate it. But there was a reason for it. It wasn't that we didn't have time in that case. But this Parliament used to meet till 3 o'clock in the morning. Tabakit, remember? It's the only time I think you got doubles 3 o'clock in the morning. I don't know, Mr. Deputy Speaker wasn't there in the Red House. We meet 3, 4 o'clock in the morning. We carried our Parliament from 1:30 on Friday evening to 5 o'clock on Saturday evening. 27 hours is a parliamentary record. So it wasn't the time, really. It was that there was still some lingering concerns with this business. And in the Parent Act, They say the chairman, deputy chairman, tribunal shall be appointed for a period not exceeding 5 years. Not exceeding 5 years. I'm looking in the amendment, and it's probably here, but I'm not seeing it immediately, whether there's a term limit for the chairman, deputy chairman, and what would be the other members of the tribunal, attorneys at law. So I'm going to come to that if we find the term limit. Or is it that when they are appointed indefinitely? We'll come to that. The quorum of the tribunal shall comprise the chairman or deputy chairman and 2 other members selected by the chairman or deputy chairman. Now, that's a most curious matter. I have not seen something like this. I haven't read every single law in the law books of Trinidad and Tobago, but I have not seen something like this before. And I really would like the Attorney General, when he was piloting earlier, he said a lot about everything. And I was waiting for the explanation as to why do you put a quorum to comprise the chairman or deputy chairman and 2 other members out of, so far we are dealing with 6, out of 6, selected by the chairman or deputy chairman. Isn't a quorum people who show up? If you have a meeting, you quorate by who show up. But would you have, why do you put it like this way? A quorum could easily be the chairman or deputy chairman and 2 other members, 3 other members, Mr. Deputy Speaker. And, you could explain it. And when you try to raise questions, they insult. You have, you pass common entrance, you have law degree, you have PhD, you have this, you have that. And some of them take 8 years to do law. Yeah, I know. But they come with this talk. But explain it. Explain it in the interest of the ordinary man. Explain it. This is a parliament. They used to pass a subject a year. You see, Mr. Deputy Speaker, explain it for the ordinary person. Don't assume you're talking to Lord Wolf. Don't assume you're talking to Lord something of something. Explain to the ordinary person and let them understand. Let's go. Appointment of lay. Now we have, Mr. Deputy Speaker, the concept of lay assessors. And that is, I think, something in the equal opportunities structure. Lay assessors. It is something also in the industrial court, because in the industrial court, a member could be a member of the court who satisfies requirement in accounting and business and trade unionism and so on. A fireman they have? Well, I could see fireman and OSHA and that type of thing as well. So you have this concept coming in now with our amendments, right? And the president may appoint lay assessors not exceeding 6 in number. So you have 6 more people coming on board. From such persons as appear to him to be suitably qualified by virtue of their knowledge and experience in the various disciplines identified under subsection 3 to advise the tribunal on matters relating to their specific disciplines. So there's a sort of advisory body being established now, an advisory body of lay assessors, not exceeding 6 in number. Again, just some clarification for the ordinary person. These persons are appointed by the president. Generally in legislation, when you hear appointed by the president, it is interpreted to mean the cabinet. But here again, they say, as appear to him. In law, him is her, so as appears to her now, to be suitably qualified. Now, what exactly is this giving rise to? Is it that the president can appoint on the basis of advice from the cabinet, but must, in her own discretion, determine the various disciplines identified under 3 and make a judgment to appoint a lay assessor? Is it that the president has no breath at all to think of that, and it goes strictly on the advice?
And they don't mention lands over there too.
Yeah. So, again, clarification. Because you see, we come to Parliament, we bulldoze our way with legislation, you pass it because you have the majority, and then next week something happened. Not next week, next year when this comes into being, or the year after, whenever. Some matter arise, and you hear looming constitutional crisis because somebody interpreted it one way and not the way that the government or the legislature meant it to be. So what is the legislature meaning here? Do they mean the president will have a discretion in appointing according to areas? Because, you know, Mr. Deputy Speaker, we have had this issue over the years. We have had this issue where cabinet recommends persons for appointment, and whoever in the chair, whoever is in the seat, decide, hold on, I have to check to see if this person is within this frame and that frame, or qualified or not. There was a case once of somebody being advised from the cabinet to appoint as a chairman. It took 3 weeks for appointment because we had to check whether it is qualified here, qualified there, whether this person is that or that. Let us just make it, simplify it, that the president, in his own judgment, appoints the lay assessors. Full stop, and the legislation provide the areas. So you take away that conflict that can arise between cabinet and president. If that makes sense, Mr. Deputy Speaker, is fine. But the Attorney General and others make the point that this is a feature of our law. It is a feature of our law. Again, if it is a feature of our law, just bring 2 or 3 examples to show us where president makes appointments from among persons as appear to them, or to her or him, to be suitably qualified by virtue of knowledge. And it has nothing to do with the cabinet. It has nothing to do with the cabinet. Cabinet cannot advise the president on this matter. 2, where the need arises or where a vacancy exists in the number of lay assessors, the president may, upon the advice of the chairman, appoint as a temporary lay assessor to the tribunal. They may advise to appoint as a temporary lay assessor to the tribunal for such period as the chairman may recommend a person with special knowledge and experience in one or more disciplines. Below we will come to that. So now you have a next issue. To appoint temporary lay assessors, the chairman of this tribunal recommends. Is this in any other law that we know? I'm asking the question. Is it in any other body that we know where a chairman of a tribunal recommends temporary appointments? I'm not sure. Subject to correction again. Because in other, I'm not sure that this obtains elsewhere. A temporary lay assessor for such period as the chairman may recommend. So the chairman has another power appointed by the Judicial and Legal Service Commission in a procedure that we believe that is not perfect at all. Now appoints temporary lay assessors for instead of a presidential appointment. So president gone, cabinet gone in that case too. And the chairman of the tribunal says to the president, a vacancy arises, somebody went on leave, somebody is sick, somebody is out of the jurisdiction on vacation. I recommend this person, put him. What is happening? What is that? I am not sure that is the best approach to take. I'm not sure. Mr. Deputy Speaker, lay assessors referred to in subsection 1(2) shall be selected from persons qualified in the following disciplines. And let me just put the disciplines. Local government, town and country planning, environmental planning, environmental science, architectural engineering or surveying, land valuation, agriculture, land management or administration, land law, or any other discipline in respect of which the tribunal needs assistance, Land surveyor. Well, they have surveying. We are not sure if that...
Honourable Member, your initial 30 minutes has expired. You have an additional 15. Care to avail yourself?
Yes, thank you.
Proceed.
Thank you very much, Mr. Deputy Chairman. So, is it land surveyor that is captured by D? If it is, maybe we can make that clear. Make it clear as to the areas that we are. A lay assessor in this section shall hold office for such term not less than 3 years as may be determined by the president at the time of his appointment and is eligible for reappointment. So there's a 3-year term for the lay assessor. 3 years. And he could be reappointed by the president. So, but the president may also appoint for more. They say not less. So it could be more, 4 years or 5 years. Terms and conditions, we discussed that already, Salary Review Commission. The president may do an order. Terms and conditions of service applicable to lay assessor shall be prescribed by order of the president. Now that order of the president, is, again, is a cabinet decision. So the cabinet determines the terms and conditions for lay assessors. So the lay assessors come in. Some people just need to learn to use, when they get phone free, they can't use it. Mr. Deputy Speaker, that has to do, you always want the best when you're getting it free. Look, he's disturbing me, he's disturbing me. I went from Lavantil West, yes. So, the terms and conditions of service applicable. So, the point I'm making is the president, as a cabinet, the cabinet advised the president as the conditions of the lay assessors. Decisions of the tribunal shall be made by members appointed under 3. Well, that's very clear. And we go. So, Mr. Deputy Speaker, there are some concerns we have with at least with the wording, not the effect, not the overall structure and the intention of the amendment bill, but the specific wording and how it can be misinterpreted. You see, in the Parent Act, the quorum of the tribunal shall comprise the chairman or deputy chairman and 4 other members. So it spells out in the Parent Act clearly what is a quorum. Here, the chairman or deputy chairman select. In the absence of chairman and so on, the decision shall be by majority vote, and they spell out, Mr. Deputy Speaker, some of the areas again that people will have. Interestingly, they have, because the tribunal members appointed are all attorneys at law, they have left out attorneys at law with experience in land law to be part of the setup, as the Parent Act had for what is called a temporary member of the tribunal. So that has gone, because the Parent Act dealt with temporary members and so on. The jurisdictional issues. Mr. Deputy Speaker, we go back to this major point raised in relation to others as well. You have a situation where this body will be called upon and can be called upon to make critical decisions that affects the poorest of the poor, but it can affect the richest of the rich, affects persons who have a dispute over 1 lot of land, but affect persons who may have a dispute over 100 acres of land, major land developers, and so on. And we are not sure this appointment process we are using for the chairman, deputy chairman, the powerful chairman, and for the lay assessors is a proper process to protect those persons from influence, prejudice. Because it cannot be, to become a lay assessor, the chairman of this tribunal, as powerful as he is, just tell the president and recommend to the president someone like that. There should be some other mechanism that we could contemplate to protect them. Yeah. And you see, it leads to the issue, and my colleagues opposite will get vexed. Because every time we talk about transparency, they get vexed. Every time we talk about openness, they get vexed. Every time we talk about disclosure, they get vexed. Again, look good start. Because they think that, when we do that, we are obstructionists and so on, or unpatriotic. But it's not that. It's that you want to put a system in place that is bulletproof, that cannot be undermined. There are complaints as well. We talk about these tribunals and so on as if this is the be-all and end-all. There are serious complaints about the working of other tribunals. The Industrial Court, the Employment Tribunal, Equal Opportunity Tribunal, other tribunals. There are serious concerns. And bringing this back in this form encourages us to analyze this, Mr. Deputy Speaker, and see how best we can do it. How best? You see, Mr. Speaker, there's a crisis, as we know, in land governance. A crisis. This was aptly captured in the IDB Framework for Comparative Land Governance Research in the Caribbean and Latin America of May 2016. There's a crisis in land governance. And the crisis in land governance to fix really do involve something like this, the tribunal, to bring predictability, certainty, and so on. But if you don't get it right, you will find the poor results as we got in this snapshot on land governance by country. And for the record, and for the member for San Fernando West to understand if he can, is where it is stated, Mr. Deputy Speaker, that the position of Trinidad and Tobago is a position that was determined by data from 2011 to today, 2017. Last year, 2017. It was portrayed as if the data was collected only from 2013 and 14. But in the report, it was very, very clear. A recent and growing body of literature pulled the threads of land governance together. In addition, the information available in documents accessible at the distance at that time vary, with land table 1 provides active country strategy information for Ecuador and Trinidad and Tobago. For the other 3 countries,
Members,
for the other 3 countries,
members,
for the other 3 countries, the data ends in 2013 and 14. It is the other 3 countries, not Trinidad and Tobago. I mean, this thing is in English. It is in English. The thing is in English. They say for Trinidad and Tobago, they pull a fast one. It is data 2011 to current. But for Ecuador, but for the other 3 countries, Mr. Speaker, the other 3 countries, it is 2013 and 14. This is why. But if we can't trust you with just reading a little report that everybody have, what can we trust you with? What can we trust you with? Mr. Deputy Speaker, in my consultations with persons and so on, and again, when you're in opposition, bills come to you. There's a procedure. There's a procedure we use. The members of the government have a different setup now because they're in government. They have a ministry, and the ministry undertakes work on your behalf. We don't have ministries, so we undertake work on our own behalf because we have to engage community members. We have to engage organizations to talk about these things. And simple questions come up. One question asked of me, which I put on the parliamentary record, will be, if and when this land tribunal come into being, what happens to all the land matters at the High Court? Are they automatically referred to the land tribunal? Do they stay in the High Court for their completion? Or they're referred? Then the other matter that comes up, which has a link to the industrial court setup as well, is that when you have a land matter, now you go to the land tribunal when it is in place. Is it therefore that you are debarred completely from going to the High Court? Or the High Court will not hear you? In the industrial relations situation, if you are a worker, you go to the industrial court. If you are not deemed to be a worker in law, you go to the High Court. What will be the setup? And again, the member for Diego Martin Northeast, a significant landowner as he is, and buyer. And he told us earlier today he was seeking out and purchasing all over Tobago and so on, you know. And Mr. Deputy Speaker, as a purchaser of luxury cars, boats, and lands, he must be in a position to help us. You know, he's a purchaser of luxury cars, land, and boats, and so on. He has at his disposal. All from a life in public service. I admire Mr. Deputy Speaker. The member for Diego Martin Northeast must be admired for having boats and land and Mustang cars, having spent 20 years in public service. Mr. Deputy Speaker, he can do that. If one of us do that here, we're in trouble. Eh? Then you'll hear more talk about search warrant and all kind of thing if we do that. But I want to tell my friend from San Fernando West, the police did speak to me. They wanted to ask me about you. And some matter involving children with guns. That's the only time the police ever speak to me. In the last year or so, they were inquiring about him. And I gave a statement, I must confess. I assume he gave a statement on that matter as well, but I must confess, as a colleague, I did give a statement on that matter. That's the only time they ever come to me, right, was to discuss you. So, Mr. Deputy Speaker, the matter now as to setting up this business. Good. We pass our bill. We have our bill in place. We beat our chests. Government pass and so on. Nice. What happens next now? We are saying and we are arguing, and no evidence has come forth from the government this day or any other day, that in those budgetary documents before you, you have allocation for a land tribunal. The Minister of Finance stood up and he says, don't bother with that, you'll get finance, don't bother with that. What you looking in budget document for? Forget those yellow books, forget that. You'll get it when you need it, I have it. And I readily believe the member for Diego Martin Northeast, he fork out $8 million to pay Liat to go and pick up from the dead collapsed sea bridge. He can find money for that, I'm sure. It is a 8 million TT of... 4 million. It's 4? By tomorrow it will be 8 million. By tomorrow it will be 8 million. Mr. Deputy Speaker, so the Minister of Finance in this cavalier manner told us, do not bother, we will finance it, but it is not in the yellow box. It is not an allocation in the ministry. So, Mr. Deputy Speaker, you have to set up, let me tell you what has to happen now. Let me tell you what, ma'am. This matter has to go to the Salary Reviews Commission. You then have to determine when you want to hire people. You have to go now and get some professional company and so on to go recruiting persons to fill
Remember, you have
these
2 more minutes.
Good. Fill positions. Then you have to go and find plant and machinery, plant and equipment. You have to get offices. You're going to go back Faizabad by somebody, so you're going to get a cabinet colleague from Faizabad to give you a next building. You have place. You have to find venues in Tobago, San Fernando, Point Fortin, Arima, East-West Corridor for Land Tribunal. So you have to have building. You have to have staff. You have to recruit people properly through a transparent process, through a company or so on. You have to refer the matter to the Judicial and Legal Service Commission because they have to undertake to recruit people for chairman, deputy chairman, and 4 other members. That takes time. With the best intentions, I want to suggest to Lavantil West, I want to suggest to him, if he will put down that noisy phone, that that process and the implementation of a land tribunal will take place under the next administration of the United National Congress. Mr. Speaker, I thank you.
Is it the wish of the House? Is it to wind up?
Yes, that was Chief Whip indicated.
Okay. AG.
Thank you, Mr. Deputy Speaker.
Honorable AG.
Mr. Deputy Speaker, perhaps my wind-up can be very short if I were to measure it by the content of the speech delivered by the last speaker. You see, I wish everything was as simple and as jovial and as jovial as the member for Oropouche East makes it out to be. Let me give you an example of what has been put on the Parliament floor by my learned colleague, the member for Oropouche East. Said with aplomb, said with sincerity, said after reflecting upon the fact of who has common entrance, high school, university, and PhD degrees. Listen to the submission of the honorable colleague of ours, the member for Oropouche East. In reflecting upon the amendment to Section 3 of the Act, where we modify the language to bring constitutionality to the position, listen to the honorable member. In reflecting upon the quorum of the tribunal shall comprise the chairman or deputy chairman and 2 other members selected by the chairman or deputy chairman. This is what the honorable member had to say. Well-lettered and learned colleague of ours as he is. Quorum? Why do you need a quorum to be put into place? A quorum is who turn up. Let me make this clear. The submission by the speaker, the sole speaker for the opposition on the law after reflecting upon how well-lettered he is a quorum should be who turns up. So what happens if one person turns up is the obvious question. The second position is that the bill has determined the quorum.
Minimum 3.
It says that the minimum is 3. And therefore, Mr. Deputy Speaker, what I find interesting is how the honorable member intends to pass off that logic as sincere contribution to a bill like this. Furthermore, it flies in the face of umpteen pieces of law. I mean, from the very standing orders, as subsidiary as they are, of this particular parliament,
we decide upon quorum issues.
No,
But the honorable
would
member,
honorable member give way?
the honorable member, sure.
Okay. Honorable Attorney General, through you, Mr. Speaker, I thought the point that Urupuch East was making was that the chairman was appointing the two members to make up the quorum. And it should be the chairman and two members or three members, as the case might be, rather than selected by the chairman. I think that was the point.
Sure. You see, the honorable member for Caroni Central tries to make sense of a submission that his colleague put forward. But if the honorable member for Urupuch East would just stop for one moment from laughing at his own submissions and making a joke out of everything, perhaps it may come across in a sensible way. But that is not the submission made by the member for Urupuch East. Again, in this debate, we find Urupuch East defending himself as to whether warrant exists or not. We're not interested in your defense. That is for the police and the courts. And the fact is, Mr. Deputy Speaker, I sat quietly while Urupuch East was speaking, but he cannot help himself. Jittery, jumpy, shaky. And Mr. Deputy Speaker, it just has to end. It is not every debate that you must come with your defense on your personal matters. Every single debate. Mr. Deputy Speaker, the bill proposes in the amendments to Section 3 of the Act, as we have circulated, that the quorum issue be managed, and it says this: the quorum of the tribunal shall comprise the chairman or deputy chairman and two other members selected by the chairman or deputy chairman. And there is nothing wrong with that. The chairman is the presiding officer. In fact, the quorum in the panel of the Court of Appeal, when it sits from time to time and the president of the Court of Appeal sits, it is the president of the Court of Appeal in our courts that selects the quorum, and there is nothing wrong with that. It's rumored that the member for Urupuch East has a law degree and is called to the bar, but I have yet to see evidence of that. Oh, Lord. The childishness of the sixth form debates. Mr. Deputy Speaker.
One second. Honorable members, please. I would like to hear the discourse of the Attorney General. Let's listen in silence. Everyone had their opportunity. Proceed.
Honestly, Mr. Deputy Speaker, the mockery and childishness that comes out of the contribution from the member for Urupuch East is sometimes difficult to tolerate. Mr. Deputy
Mr.
Speaker,
Speaker, I am depending on you to protect me from these insults and offensive language.
Member?
I'm not getting that. I'm not getting that.
Member? Overruled. Proceed.
Mr. Chairman, Mr. Deputy Speaker, let me make this abundantly clear. If you want to talk like a man, throw threats like a man, behave like a man, you have to be prepared to take blows like a man. Right? Honestly, there has to come a point in time when the childishness must end, and I will stop there. Mr. Deputy Speaker, this is serious work. The submissions coming from the speakers, the sole speaker for the opposition, happen to have fallen from the lips of Urupuch East. When one makes a submission to say the quorum is who turns up effectively, it is most respectfully a submission that one cannot take seriously. Mr. Deputy Speaker, we heard the same old. Operationalization, how is it going to come? We then witnessed a surgeon into current issues of the SRC and terms and conditions associated with Section 141 of the Constitution as they fall in aid of the protection of the separation of powers in this bill. The honourable member asked what was meant by practice of land law in looking to the positions. And hear what the honourable member said. There's no registry for that. Mr. Deputy Speaker, the Law Association of Trinidad and Tobago, so comprised under legislation, has organized itself
so that practitioners every single year when they get in a practicing certificate indicate the areas of law that they practice in. The honorable member is an attorney at law called to the bar and does not know that yet. Every other lawyer in this country is aware of that. But this lawyer, the honorable member as he is, does not know that. And is exercising parliament time to try and tell us with a straight face they have no registry. Mr. Deputy Speaker, if you're going to make a contribution, at least learn what the practice is. At least bother to get what the position is right. Mr. Deputy Speaker, again, self-defense, muttering. Mr. Deputy Speaker, the honorable member, Mr. Deputy Speaker, I crave your protection from the ramblings of Oropuch.
Member for Oropuch East, you had your opportunity, and as the AG said, he listened. So please, let the AG have his opportunity now. Proceed.
Mr. Deputy Speaker, the honorable members opposite, through their spokesman, spoke to having serious complaints and said that, look, it wasn't just that we allowed the legislation which is now before the House to lapse on 3 occasions. It wasn't just that it lapsed on 3 occasions, but that there were serious complaints. And then the member failed to go on to explain what the serious complaints actually are. The honorable member, in asking about the appointment of the judiciary and in looking to the mechanism that is suggested in this bill, that the Judicial and Legal Services Commission appoint the operatives of the tribunal, so to say, then went into a surgeon to say, well, the current system has difficulty. Is the honorable member speaking for the opposition to say that they propose deep entrenched provisions of the Constitution to be amended? And if that is the case, why is it in the full 5 years and 3 months that the honorable members opposite had to govern this country that we had no form of constitutional reflection for amendment brought to this parliament? Is it just do as I say now? Are we not to judge them quite legitimately in the advanced argument that there were serious complaints? Shouldn't we look to the track record of the UNC to see whether there was in fact a submission that can hold water? I respectfully submit that the representations brought by the honorable member for Oropuch East are incapable of holding water. I respectfully submit that the constitutional arrangements and statutory arrangements for the appointment of tribunals and other entities, be they strict courts of superior record or inferior tribunals, are well established in our country. They have long form of precedent and structure, and generally speaking, Mr. Deputy Speaker, there is nothing to be answered from the member for Oropuch East. Nothing. In those circumstances, Mr. Deputy Speaker, I beg to move.
Honorable members, the question is that a bill entitled An Act to Amend the Land Tribunal Act 2000 be now read a second time. All in favor say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Land Tribunal Act 2000.
Attorney General.
Mr. Deputy Speaker, in accordance with Standing Order 68-1, I beg to move that the Land Tribunal Amendment Number 2 Bill 2017 be committed to the Committee of the Whole.
Honorable members, the question is that the Land Tribunal Amendment Number 2 Bill 2017 be committed to the Committee of the Whole. All in favor say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Clause 4 is uni. Clause 4, Chief Whip? Right. So therefore we'll do 1 to 3, clause 4, and then we'll do the others.
Clauses 1 to 3.
Clauses. The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stands part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill.
Yeah.
Member for Point Pierre.
Thank you, and maybe the member for East will go after. AG 4.5, the quorum of the tribunal shall comprise, I'm not a lawyer, I'm just reading as a normal individual. The quorum of the tribunal shall comprise the chairman or deputy chairman and 2 other members selected by the chairman or the deputy chairman. The word selected gives me very grave concern, just like the member of Oropouche East and the member for Caroni Central, because it connotates that this quorum
I just wanted to add to it. It's the same
You want
point.
to add Oropouche East?
Yeah, it's the same point. Through you to the Attorney General. Attorney General.
Attorney General, you're with us, right?
Yeah,
Right. Okay,
we're
go ahead,
not, we're not
Oropouche
in the cut and thrust of the debate, but really at the committee stage now to speak specifically. What would we lose if we just put the quorum of the tribunal shall comprise the chairman or deputy chairman and 2 other members, full stop? What do you lose?
Attorney General.
Mr. Deputy Chair, Mr. Chair, forgive me. The proposal for the selection by the chairman is so that we don't have to enter into any casting vote arrangement or disagreement arrangement. It is the presiding person, the seniority of rank, that shall have the privilege of constituting the quorum. And that is the real reason why. If we were to simply have it that way, in this particular tribunal, we may potentially be inviting this court. What this does is to add a degree of clarity by saying that the chairman, or if it is the deputy chairman who is presiding, shall be the person to select the other 2 members. And that obviously happens because there may be, in the arrangement of the tribunal, the selection of persons who are appropriate for the particular matter that is being chosen. And because this thing is a wide-range subject position, it makes sense, therefore, to allow that chief adjudicating entity, that person who handles the tribunal aspect, to have that discretion expressly stated in the legislation. And for those reasons, we prefer to leave it as it is.
Chairman, could I respond?
Oropouche East.
Now, I'm very happy to hear this because in the presentation in the debate, unless I missed it, I didn't get this explanation. So it means, therefore, that the chairman or deputy chairman, one or the other, gets the right to select 2 others to form a quorum on the basis of specific matters before the tribunal. Would that not cast some other type of danger in creating a quorum that way that could prejudice or create another set? I just want to complete the point, because now in the explanation given, there's a point in that explanation where you are leaving out someone. You might be leaving out someone because they don't have explicitly a discipline or a training or a qualification in a particular area. And I find that a little harder to swallow than just saying select 2. So you're saying that if we leave out that and you just put the full stop by members, you could disadvantage the tribunal in some way in hearing matters. Is that it?
Mr. Chairman, the submission by my learned friend is built upon a premise that nobody else could turn up. The entire argument, therefore, falls flat on its face because there's no prescription against other members turning up. The quorum is the bare, basic minimum of who shall be lawfully there to actually proceed with the matter. So the submission just collapses on the back of the supposition that other members are debarred. There's no limitation. On the other hand, in terms of the position put forward by me a short while ago, in a de minimis sense, it may very well be that the chairman ought to select who should attend depending upon the matters, and therefore prescriptively, one ought to be careful to allow for the discretion to be exercised by the person who has the control. It is no different from the Court of Appeal structure, where the president of the Court of Appeal may select certain matters. The Chief Justice has the option to comprise the Court of Appeal, to sit on occasion in the East Coast or the West Coast, and to comprise the panel. And it is no different from that.
Could I just... Member for Naparima, you had your hand up.
Through you, Chair. Help me to understand when you say that when it avoids the problem of the chairman having to have a casting vote. If it is the chairman and two others, how does that arise? The need for a casting vote.
AG.
Well, Mr. Chair, what happens if the other two have a differing point of view
And
to the position?
And how does the chairman selecting the two get us away from that problem?
Because it is in his discretion that the other two shall comprise the quorum. So there's no exception to it. If you look at it, the chairman, deputy chairman, and other members, the quorum of the tribunal shall comprise the chairman or deputy chairman and, just let me get the actual wording of the bill.
And two other members selected.
And two other members selected by the chairman. So the quorum shall comprise the chairman or deputy chairman and two other members selected by the chairman or deputy chairman. It puts it beyond doubt. It is the chairman who will comprise the de minimis quorum. Anybody else could still turn up.
So what happens if two turn up, but those are the two not selected by the chairman?
Well, then there's no
don't
quorum.
have a quorum.
There's
That
no
sounds-
quorum.
it sounds-
Mr. Deputy Speaker.
So hold on. Point up here. You still have a point or you give way? All right. Caroni Central.
One thing the Attorney General appreciates the logic of what he's saying is that the chairman and two people who will agree with him will constitute the quorum. That is the logic of what he's saying. I just want to draw it to his attention. I know it will make no difference, but that is the logic of it.
That's a self-defeating argument if you know it'll make no difference, most respectfully. But the point is that this is no different from what is actually in operation in our very own judicial cycle, or in other matters where there is a discretion to the chief person in charge of the entity.
Well, Chairman, maybe that's why we have so much problems in the court. It may well be. But I want to put it to the Honorable Attorney General, because I don't intend to talk on this all night, but the Attorney General is saying that a chairman could appear for a matter, two other members could appear, and that is not a quorum. Then the chairman is saying, the Attorney General is saying, as member for Caroni Central, that the chairman decides on individuals to come to make a quorum, to take decisions on what could be critical multi-million-dollar issues involving land. That is a serious, serious danger that we are legislating into law. And I leave it at that. I leave it at that.
Point up here.
Thank you, Chair.
Members, please, let's hear point up here.
And respectfully, I mean, all day we were here debating land and talking about land being very dear to citizens and sensitive to citizens. Right? Even the Prime Minister came and talked about Tobago lands, and he understands the sensitivity and the concern. And we are here tonight at the 99th hour, in a sense, and we just haggling over a word in where this clause is not giving people comfort that they will be properly heard and adjudicated on. It leaves, there's a lot of room for mischief and doubt by the people.
Mr. Chairman, I took the opportunity to speak with the drafter of the bill, who indicated where the origin of this came from through the consultative process that had continued over many years. Whilst I don't necessarily agree with the submissions offered by my learned colleagues, I am prepared to make an amendment to end that sentence at the word members, and that would simply be in the effort to move along tonight.
Thank you very much, Mr. Chairman.
And in fact, it should read, Mr. Chairman.
Let's listen, please.
It should read, the quorum of the tribunal shall comprise the chairman or deputy chairman and insert the word any other, so we should insert 2 words, any other 2 members, full stop.
Mr. Chairman, thank you very much. It may not mean a lot to the Attorney General, but I think this is a significant change.
Okay.
But I have another matter in 4.
With clause 4?
Yes. Yeah.
Okay.
No,
Puchis.
Thank you very much, Mr. Chairman. We are moving past the issue of the quorum now. I had made I made a point in the debate, Mr. Chairman, concerning what would be here 3A2, where the chairman, we go back to the chairman advised the president on who to put as a temporary lay assessor. I made the point that this is, again, a very dangerous thing. This tribunal could be hearing big matters involving multi-billion-dollar lands and so on. And the chairman who is hearing a matter and who is running this tribunal knows of vacancies here, somebody going on leave, vacation, sick leave, somebody is ill and so on, then decides who comes in with what skill to act for a particular time. You know, and the time I think could be 2 years, unless I'm not mistaken. But he decides who comes in to act, and that same person, if we didn't change 5, he also could be part of the quorum. But we just changed 5, so it's changed. So I'm asking the Attorney General whether we should find a slightly different formula for an acting appointment as lay assessors rather than the chairman deciding who he wants to bring in, because there might be a specific matter and collusion comes in, corruption comes in, and he brings in somebody to suit the bill.
Mr. Chairman.
AG?
Yeah. I understand the point that the honourable member is making. What I have to ask the honourable member is a square question. What does the honourable member propose? We are in committee stage with a bill that has stood on the order paper for 2 years. We don't have a circulated amendment, and we're basically in an argumentative approach towards it. Does the opposition have a specific recommendation? If so, could I have it in specific terms?
Specifically, again, I think it could become simple to read, Mr. Chairman, where the need arises or where a vacancy exists in the number of lay assessors, the president may appoint as a temporary lay assessor tribunal for such period as the chairman may recommend, but the president appoints. And the chairman have to say only the time, because it has to do with the period. A person with special knowledge, and you have the full list of knowledge and disciplines below. Just allow the president to make a temporary appointment for a time decided by the chairman, who will know what time is available.
So, Mr.
So
AG?
is the member saying simply delete the words upon
Advise
the advice of the chairman?
Yes.
That's why I was asking you to state what you intended.
Yes, well, I read it and excise it, so I'm saying take out upon the advice of the chairman. What do you lose?
So that the president.
The president may appoint.
Mr. AG with us?
Yes, sir.
And in this case, let us be clear, the president means the cabinet. But at least there's some check and balance there. Bo? Should use the president in their own judgment.
Mr. Chairman, that would be agreeable, that we delete the words upon the advice of the chairman.
Is that okay? Or you want to say the president? Leave it? Yeah.
Mr. Chairman, that would be at page 3 of the bill in subclause 3A2, appearing in the third line, delete the words appearing after the comma. So delete from and including, comma, upon the advice of the chairman, comma. Are there any other submissions from the members opposite? No?
Thank you, members.
Good speech, man.
So, may I, Mr. Deputy Chair, Mr. Chair, forgive me, the member for Pointe-a-Pierre is asking if I could read back. So
Okay.
for clarity, the 2 amendments would be as appearing on page 3 of the bill in relation to clause 4. The first amendment would be at clause 4, which proposes the insertion of a new subclause, a new section 3, section 3.4. After 3.4, let's go to 3.5, which is the top of page 3. The quorum of the tribunal shall comprise the chairman or deputy chairman and any other 2 members, full stop. The second position would be in the 3A, that is dealing with the appointment of lay assessors, subclause 2. The clause would read as follows. Where the need arises or where a vacancy exists in the number of lay assessors, the President may appoint as a temporary lay assessor to the tribunal for such period as the chairman may recommend a person with special knowledge and experience in one or more disciplines listed in subsection 3.
The question is that clause 4 as amended The question is that clause 4 be amended. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 4 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 5 to 8.
The question is that clauses 5 to 8 stand part of the bill. The question is that clauses 5 to 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands. Sorry, clauses 5 to 8 now stands part of the bill. Honorable members, the question is that the bill, as amended, be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Thank you, members. Attorney General.
Thank you, Mr. Deputy Chair. Mr. Deputy Speaker. Mr. Deputy Speaker, I wish to report that the Land Tribunal Amendment Number 2 Bill 2017 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that this House agree with the committee's report on the Land Tribunal Amendment Number 2 Bill 2017. All in favor say aye. Aye. Any against? The ayes have it. Attorney General.
Mr. Deputy Speaker, I beg to move that a bill entitled An Act to Amend the Land Tribunal Act 2000 be forthwith read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Amend the Land Tribunal Act 2000 be now read a third time and passed. All in favor say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Amend the Land Tribunal Act 2000.
Honorable members, at this time, we will suspend and we'll return at 10 o'clock. Right, at 10 o'clock.